stops, no one knows. We're going head into the unknown. Na, 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 na.
Well, hello, everybody. Happy Monday morning, well, or afternoon or evening, wherever you are in the world. Welcome back to Criminality, or if this is your first time here, welcome to Criminality. Welcome back, guys. Happy Monday. So today we are continuing talking about the state of Iowa versus Todd Mullis, but we have completed the entire trial from 2019 as well as the sentencing. And so today we're going to be starting off with the appeal hearing and the appellate decision, which, as we know, was affirmed. And then we're going to get into the post-conviction relief hearing that actually just happened a couple of weeks ago. So let me say hi to you guys real quick. Hi, Post-Punk Mama. What's up, Lacey? Hi, Carla. Hi, Heavy Metal. Hi, Thomas. Hi, CT Girl. Hi, Indiana Girl. You guys ready for this? Are you ready? Are you ready for this? Okay. Hey, Laura. Okay. And happy St. Patrick's Day. I hope you are all wearing green so you don't get pinched. And have a pint for your Irish friends. Let's get ready to rumble. Hi, MB. All right, let's get this up and started. Okay. Make sure you guys can hear it. Make sure you guys can hear it. So this is from his appellate hearing. So we're going to see the same attorney that we just watched on Friday at his sentencing. So that was his appellate attorney.
The Iowa Court of Appeals is now.
Let me see if I can get it.
Please be seated. Good afternoon and welcome to the Iowa Court of Appeals. We are here today for two oral arguments. The first case set for today is State of Iowa versus Todd Michael Mullis, file 20-1173. The appellant, Mr. Mullis, appears through counsel Aaron Hamrock. The State of Iowa is present through Assistant Attorney General Bridget Chambers. So counsel, when you're ready to proceed.
Indiana Girl, I believe this is 2022.
Thank you, Your Honor. May it please the court.
Hey, Anja.
This case is a sufficiency of the evidence case, and one of the main reasons that we've asked for a bit of time to be able to stand here and speak to the judges.
Sound okay for you guys?
Is because it's very important. And on page 12 of our brief, we've put an aerial photo in that was exhibit number 111 at the trial stage. But in this particular case, and I've had an opportunity to visit the property, and to understand the sufficiency of the evidence argument, in looking at page 12 and the aerial photo there, it's important to note that on the morning of November 10, 2018, Todd Mullis and his son were at another area planning to do some chisel plowing and other farming stuff. They came back to the property because they weren't allowed to do it due to the weather. Came back to the property, had some breakfast, and they raise a lot of hogs, and so they needed to get these hog barns ready for the hogs to come in and be able to be raised through the winter. So Mr. Mullis and his son were out in what's marked on here as 10 and 11, which would be the north hog barn. And these hog barns themselves are about 100 yards or a football field in length. And at the very west of the hog barn, you can see a little white chute that comes out. That is a chute where semi-trailers can back up to when they're going to load or unload these hogs. And, that chute stands about 6 feet tall or so. The other entrance into the barn is at the southwest corner. There's a door that leads into the office, and we've talked about the office and where the spigot is at, where the son, Tristan, went to get a couple of drinks while he and his father were working in the barn that morning. The only other exit from the barn would be at the very east end of the barn, about halfway between the two corners, which is a big sliding door to get out, and that would be the other exit. In this particular case, the evidence that came in at trial was that Tristan, his father, and Amy Mullis, the mother, were all working in the barn for a period of time. Now, Amy had a medical procedure 3 or 4 days prior to this. Amy was not feeling well. Tristan and his father indicated to Amy, you should go back inside, but if you could, over where it says red shed, there was a pet carrier located in there. They wanted the pet carrier because they had to do some work after they were done in the barn over in the red and white shop, which is clearly marked on the photo as well. In that shop were a bunch of cats that ran around in there. They didn't want to run them over with the heavy machinery that they were going to be moving around to do the work that they needed, so they requested the pet carrier. So in this case, we know that Amy leaves. She's requested to go get that out of the red shed. Tristan continues to clean light fixtures that are in this hog barn, and his father continues to put in the nipples for feeding of these hogs when they get there. They're together, we know, in this hog barn for about an hour and a half total, according to the evidence. We know at a period of time after Miss Mullis leaves is when Tristan goes to get a drink of water. He gets that drink in the office where there's a spigot and a small hose, turns it on, drinks some water, turns it off, goes back to work. They were working right around the corner from the office there towards the west end of the barn. Now, we don't have an exact amount of time to get 2 drinks of water, but common sense, I think we know that would be no more than a couple of minutes to get those drinks of water. So what would have had to have happened here, because Tristan never saw his father, the testimony was, never saw his father.
No, so this case is her falling in a shed against a corn rake. Now, to the state, it's that Todd Mullis, her husband, hit her multiple times with a corn rake. Let me see. I think he did it. I've never fallen or seen anyone fall straight back and landed on my back. People put their hands out to catch their fall or land on their rear side. Okay, so I think that the post-conviction relief hearing will probably be very good with the biomechanics of the whole thing. Because in my opinion, I think the corn rake was propped up, and I think she fell against it, and then tried to get off of it, could not get off of it completely, fell back against it, just at a very light angle. So the third one, and then tries again, and then falls back on it more completely, and then falls down to her hands and knees trying to get to the door to go get help. I don't think there's any falling on her back, because she's found, she's on her hands and knees. So I think she fell against it. I don't necessarily think she fell on it. I think she fell against it. I hope that makes sense. Hi, Christine. What's up, CH? That's okay. You're fine. We'll fill you in. We'll fill you in along the way. What's up, Labrant? Yeah, so that's just my opinion, and I've only watched 2 days of the post-conviction hearing. So anybody who just popped in, this is the appeals hearing back in 2022. So this is when they're appealing his conviction. Yeah, see, I don't know. I don't agree with that. I don't think it is. I think it's part of the corn rake. But that's, I mean, shit, I'm no expert. It's just me.
Leave this hog barn. What would have had to have happened is Mr. Mullis would have had to have sprinted down almost the entire length of the hog barn to the east, exit through the doors down at the east end of the barn, go about 20 yards south to the area between the north and south hog barn, sprint back up that area, which would be another 100 yards. And then there's a period of feet over to where the red shed is. Okay, he would have had to have located Miss Mullis there, and somehow he would have had to have known she was still there and didn't already retrieve the pet carrier and go on inside. But he would have had to have known that she was there, go over there, commit the assault, and then run all the way back and get back into position, doing the work that he's done, not being out of breath, disheveled, or anything else, prior to his son getting that drink of water, walking back around the corner and starting his work again. They were the only two people in this barn. So it's not like it was a crowded barn and Mr. Mullis could have gotten lost somehow, or he could have taken they were the only two people working together after Miss Mullis left in this barn on November 10, 2018.
The evidence that the family were the only people present at the farm that day?
That was the evidence, yes.
Aren't in a sufficiency of the evidence challenge, don't we need to view the evidence in the light most favorable to the state? So how do you square that with how you've presented the facts on appeal?
We believe that this was an accident. We don't believe that this was a murder. I understand that there were some of that had been conceded previously at the trial level, but realistically, that's how I look at the facts and looking at the sufficiency of the evidence. It would be physically impossible for Mr. Mullis to have traveled the only way he could have gone to not be seen. And by the way, the evidence was while they were in the barn, they would wear a special boot covering their shoes so they wouldn't track disease from outside inside, which could get the hogs, which are expensive, get them sick and cause them additional money or death. So that's on top of everything else that he has these special boots on that he would have taken off. So
Your argument that this was an accident with the autopsy reports that indicated there were more than one set of entry wounds into the victim in this case.
That could be explained in that if Miss Mullis did slip, fall, got dizzy, due to her medical procedure, and there were some questions about, Miss Mullis, or some testimony about Miss Mullis not feeling well and being dizzy. If she slipped and fell and she impaled herself with this corn rake or corn fork, a person's first inclination, most of the time, if you get a splinter into your hand, or you cut your arm or your hand with, let's say, a piece of glass, your inclination is to remove that. Very well, it could have been her inclination to remove, reach back and pull that out, get it out of her. Did she slip or fall again? Very well could have. Did she possibly pass out? Could have. We don't know the answers to that.
We're not to
but
him yet,
that
silly
is
goose.
certainly
I
an
will come in.
explanation as to, there being the 6 puncture wounds.
Emrock, your client did not claim that it was an accident at trial and testified that somebody had to have done this, just wasn't him. What is the direct evidence or even circumstantial evidence that anyone besides Mr. Mullis committed this crime?
And that's assuming that it was, Your Honor, that it was a crime and not an accident.
It testified under oath that it was not an accident.
He was told that.
We don't have any evidence that anybody else was on the property that day. I have not heard anything come forward.
See, I hate this part because he originally had told everybody it was an accident. It was an accident. It was an accident. And then the cops tell him it was a homicide, that somebody killed her. So what is he supposed to concede then? That he still thinks it's an accident because they're telling him all the evidence points to that it's not an accident. I don't know. This could go either way. I think just depending on how you view the situation. But for me, the cops are constantly telling him it's a murder. What is he supposed to do with that information? Yeah, heavy metal. I think the biggest thing is going to come down to there's no way that this big ass dude, Todd Mullis, was able to even swing a corn rake in the area that they're accusing him of swinging it. There's just so many things to it. And his son only had him out of his sight for 2 drinks of water for about a total of 1 minute and 40 seconds. And that's combined for 2 drinks of water. It's just, I don't know. I don't know. I'm just, you guys, anybody who's watched this so far with me knows I don't think he did it at all. I think it was a freak farm accident.
Did that if this was a crime, did that happen? It certainly could have happened, and they didn't see anybody. They were in the hog barn working that day.
But what evidence is there that anyone else was there? Was there any direct evidence, any physical evidence, any witness testimony, anything?
They keep telling you
circumstantial,
it's not a crime.
direct evidence that another person or people were there besides the family.
Thank you.
Somebody wasn't there. I just don't have any evidence enough.
In terms of weighing the evidence, there's a weight of the evidence claim in this file.
In looking at what would have had to have happened, the physical portion of this, it would be simply impossible. Thank you.
We'll have an additional 5 minutes on rebuttal. Ms. Chambers, when you're ready.
Hey, welcome to being a member, silly goose.
May it please the court. This is not a close case. The evidence of Todd Mullis' guilt is simply overwhelming. Only Todd Mullis and his son Tristan knew that Amy Mullis was going to that red shed. Only Todd asked her to go there. Only Todd placed the murder weapon in that shed within a month of that time. Only Todd had multiple strong motives to kill Amy. And only Todd, while purportedly giving her CPR to save her life, whispered, "cheating whore," and "go to hell, cheating whore." The defense has suggested a number of things that certainly could have happened. This is a sufficiency review. This court cannot reverse on speculation of things that could have happened. The court must look at the evidence in the light most favorable to the state and determine whether the jury could reasonably have reached a guilty verdict. This record absolutely supports the jury's guilty verdict. First, let's look at what did not happen. There's no evidence of a break-in. There's no evidence of a burglary. There's no evidence of a sexual assault. No other person was identified as being at the farm other than Todd, Amy, Tristan, and the 2 younger children who were in the house. The only people on the farm who could have committed this crime is Todd. The two youngest children would have been elementary school aged at the time of the crime. Clearly, they did not plunge a cord and fork into their mother's back. Tristan was in 7th grade and 13 at the time of the crime. And Todd Mullis, if you look at the photographic and video evidence, is a strapping adult.
A strapping adult.
All of the evidence
Really?
points to only Todd as the murderer in this case. It was Todd who sent Amy to the shed. He sent her to the shed to get the pet carrier, knowing that it was well inside the shed in a place that would be out of sight from anyone outside the shed. He also knew that it weighed 15 to 18 pounds and that Amy's doctor had advised her not to carry more than 10 pounds.
Oh my
Yet,
gosh.
after
no
she was
way.
dizzy in the hog barn,
I think it was like a
he sent her
15-pound
out
carrier.
to get the pet carrier.
There was no, I know.
How do you respond to the defendant's argument that it was physically impossible for him to have had time to get from the hog barn to the red shed to commit the murder?
There are there are two assumptions underlying that conclusion on the part of the defense that are not justified here. So first of all, the defense seems to believe that just because Tristan did not see his father leave the hog barn, he must have gone out the east doors and run all the way to the red shed, which, by the way, is about 100, would be at the most, not taking any shortcuts, would be about 150 yards. Todd is a young man who appears at least to be in good physical condition. That
No,
would not
just
be
fat.
a marathon for him. But it also assumes that he did that. So Todd and Tristan were working in
He
the
was
same
very heavy at
immense
that time.
building, each doing their individual jobs. Tristan's job was cleaning the light fixture, so it involved him looking up towards the ceiling. He was also 13. He was not keeping track of where his father was every second of that morning. For them, this was just a normal morning on the farm. Tristan had no reason to have heightened awareness of where his father was. His father was putting up the nipple bars. If you look at the photographic exhibits, you can see that the hog barn is divided up into pens, and some of those have solid panels. So it would be very easy for Todd to have been someplace in that building where Tristan couldn't actually lay eyes on him, and yet Tristan logically would have thought they were both there together.
Could you respond to Mr. Mullis's argument regarding the number of puncture wounds in the victim's back and whether that could be an accident if she fell once or twice on that particular piece of equipment?
Is it impossible? Maybe not, but this is a sufficiency review. And the odds...
She doesn't even care. She doesn't even care if it was possible. She's like, you don't have the right to even speculate because this is about efficiency of the evidence and you don't have a right to speculate whether this was an accident or not, even though it's very possible it was.
The jury could extremely reasonably have determined that Amy Mullis did not fall on her back twice that morning.
Never said that.
That she fell once and somehow was, and those, let me point out too, that those wounds were not superficial scratches so that she could have just reached back and moved that fork out of the way. They were deep, penetrating wounds. The odds that she was able to pull the fork out of her own back and then somehow manage to fall on it again really defies credulity. And the jury acted reasonably in not following that path.
She doesn't even know what
I would
she
also
she doesn't
point
even know what
out,
she's
as the
talking
court
about.
has recognized, that was not the theory in the trial court. And on sufficiency review, the defense does not get to change their theory. Todd Mullis testified that he thought someone inflicted that wound, and that's the jury. That's the theory that the jury was evaluating.
Chambers, as I understand the autopsy, there was defensive wounds on the left hand of the victim. Was there any evidence that Mr. Mullis had been in a struggle, like any evidence of disheveled hair, wounds to his face or hands, torn clothing, blood on his clothing, blood on his
Shit
boots,
shows that are better.
anything like that?
No, so I would first state that those defensive evidence sort of undercut the theory that maybe that Amy fell on the corn fork twice. But no, there was not evidence of blood or wounds to Todd Mullis. But remember that he would have, by the time the police saw him, or by the time anyone other than Tristan saw him, he would have already carried Amy's body to the truck he would have helped get Amy's body back out of the truck where the deputy met
Doesn't matter.
them
He
and
still had
performed
zero
CPR.
scratches.
So if there had been blood on Todd Mullis, that wouldn't have drawn any surprise. There was no evidence of bruising or wounds or scratches, but again, not horribly surprising. The fact that Amy had scrapes on her doesn't mean she struck Todd in some place where it would cause injuries on him. It was a cold day. They were wearing heavy clothes.
Keep beat. Make sure you stick around because we're going to see a
Presumably he was
reenactment done
behind her.
in the post-conviction relief
That was part
hearing.
of the
So
thing.
I think I think
Todd had
that with the
extremely
trial,
strong
the
motives
lack of
to-
visual aids and the lack of reenactments, which is the whole premise of the post-conviction relief, is that his defense attorney literally did nothing. I mean, he just literally did nothing. He called nobody. He got no experts. He just did nothing. And then he conceded that it was a murder, which makes zero sense, that somebody else was even sneaking on the property to do it. And same concept, even if you did go with third party, you have to have somebody who would be able to swing this rake in this tiny little space in this shed. And it just does not make sense. So post-conviction relief, those attorneys actually bring in a whole slew of experts to show the judge, like, listen, we had ineffective counsel. The counsel's going to testify and tell you how ineffective he was. And then we're going to put a whole slew of experts on here to explain exactly what we believe happened based on physics, biometrics, everything else. So, yeah, I mean, it's going to get even more interesting. Hey, Sleuthie, we are currently watching the appeals hearing from 2022. This is the states. Hey, Rexy. So you've missed about 18 minutes so far. You missed the original, what would you call it? What do you call it? It's not testimony. The original speech. I can't even think of the right word here. From his regular appeal. So from his appellate attorney, who his appellate attorney is much, much better. Argument. Thank you, CH. I'm like, I don't know what the hell's wrong with me. I can't think of the damn word. And now she's doing her rebuttal, and then he'll come up again and talk.
Kill Amy Mullis. He knew that his wife was having an affair. The affair began in May or June. By July, Todd Mullis was sufficiently worked up that he confronted Jerry Frasher and Jerry Frasher's wife about what he believed was an affair. Todd Mullis was angry. Todd Mullis also had a motive to kill Amy based on the fact that it would be a financial disaster for him. Amy Mullis testified or told a friend that her share of the family farm trust was about $2 million. And if they divorced, Amy would get that $2,000. Todd had also told people over the years, once right after Amy's first affair, he told Eileen Fuller that he was working things out with Amy because he wasn't about to lose the farm he'd worked for his whole life. In August, before Amy was murdered, Todd told their mutual friend Terry Stainer that he would, who was really kind of trying to gently encourage him to just divorce Amy. Things weren't good. They all knew it. Maybe he should just reconsider whether he wanted to stay in that marriage. And he told her that, and I quote, "I've worked for this farm since I was 11 and I will not give it up." Todd was angry. Todd's third motive regards his kids. He had not been an attentive father, the record shows. He had not been close to his kids. Shortly before Amy's murder, he had tried to kind of move closer to Tristan and had apparently made some success in doing that. But he wasn't the father going to the dance recitals. He wasn't the father going to the gymnastics meets. He was not the father cooking, cleaning, and taking care of the kids. He was not going to get custody of those kids, and he knew it. And if Amy died, all of those problems went away.
She wasn't even taking the kids with her. Why don't you fucking shut it, lady?
There's also abundant evidence that Todd had ongoing concerns about unfaithfulness. On Christmas of 2017, Todd was researching cheating women. Amy's friends testified that he kept her on a very short leash, and she essentially had to check in and out when she went places. By May of 2018,
such a short leash that she's able to go out and bone fucking Jerry Frazier on the side of the road frequently, over 100 times, giving him roadhead. Bullshit. Tight leash. I don't think this lady knows what a tight leash is.
Online for evidence about other cultures and whether they killed adulterers. He looked at a newspaper article about a husband who killed his wife and what the sentence was. He looked at multiple ways of killing someone and how does one survive different situations, all suggesting that he was considering different methods of killing his wife. In the short time I've left, I just want to talk briefly about Todd's reaction to Amy's death and to being told that she was murdered. He showed virtually no interest in finding out what happened to Amy. There were video cameras on the farm, one of which was pointed at the Red Farm. He didn't even mention that to law enforcement. He didn't check them until the day after Amy died, when other family members suggested it. When he saw that the camera had been knocked out of the window, not knowing when that happened, he just went,
Why would you recommend to the cops to go look at the surveillance video when you believe it's an accident and there's no video from the red shed? There's nothing in the red shed that would be useful on surveillance if you believe it's an accident. Like the common sense tells you you would not, you think that she fell and she hurt herself inside this shed. There's no camera inside this shed. They act like there was a camera pointed right there, right where she died, and it wasn't working, and he never told anybody about it. The camera would never have even helped. Who was watching the kids when he was working and she was off with her boyfriend? Well, luckily, for them, the majority of their farm work was right there on the property, but not all of it. So they also were in school. So you get that too. You get the time that she's out going to quote unquote lunch with Terry, where she's leaving Terry so she can go have makeup sex with Jerry. Ugh.
I guess must have been out, doesn't show anything. He never checked. Those are not the actions of a husband who wants to know how his wife died. And when officers told him that she had been murdered, there was no outrage, there was no shock, there was no crying, there was no emotion. He simply said, there's no evidence. This is not a man who was grieving his wife who died of an accidental injury.
You're a liar. That's not what he said.
Mr. Hamrock, rebuttal when you're ready.
I hate mustard, by the way. She just looks like a bottle of mustard.
Thank you, Your Honors. With respect to, the state talked about motive and talked about some computer searches that the state wants everyone to believe that Todd Mullis completed. Well, first of all, a computer search for over a year ago from the time of this accident, is stale evidence at best. Let alone trying to say that, because of this computer search, and we believe that Todd is the one that did it, when the evidence was that lots of people had access to this iPad. The kids used it, Amy used it, his brother Mike used it, other family members may have used it. Doesn't necessarily mean that Todd was the one doing searches. So they also talk about, for instance, Todd and Amy's daughter was doing some research because she was getting her hunting license and had to know, I don't have a hunting license, so I don't know all the details of the test, but was studying for the test. The state also talks about, and the question was posed, there were not, the 6 wounds were not all on the back. As I recall, the autopsy report, I believe 4 wounds were towards the back side, and then there are 2 wounds that I believe talked about the right side of Amy's body, not on the back. That very well could be consistent with somebody who did pull the rake out, panic. That's what they wanted to do. They wanted to get it out. And if she slipped, she fell, passed out, whatever, could easily explain why there were 2 puncture marks on the right side, not on the back.
Witness acknowledge that was a possibility, specifically the medical examiner?
I don't recall if the medical examiner may seems to me may have been questioned about it, and we'd have to refer to the transcript to be positive, but may have been questioned about it. And, one of those, well, I suppose it could be possible kind of answers, but I can't stand here and point you to the exact line that was set at.
Respond to the state's error preservation argument regarding the sufficiency of the evidence issue. Do you believe that you've preserved error beyond just the identity element?
Your Honor, I do believe that error was preserved. We put in our reply brief, we specifically outlined it where trial counsel, in talking about it at the trial court level, made it very clear in arguments that this was sufficiency of the evidence as to intent and as to whether or not Mr. Mullis was the person that committed the crime. So I believe that it was clear. And, there's also the State versus Foley case decided by this court back in 2017, which talks about essentially that, under the circumstances of that case, the record clearly revealed the trial court and counsel understood the grounds for the motion of judgment acquittal targeted the insufficiency of the evidence to support the first element of assault due to limited physical evidence and the hearsay nature of the testimony. So I believe that error has been preserved in this case.
So could you respond to the state's comments about your client's statements on the 911 call when he's performing CPR?
My response to that is I can't believe that the prosecutor actually kept saying that and was allowed to say that. There's no evidence of that. You can't hear any of that. That was very disturbing because clearly Mr. Mullis did not make any of those statements and should not be considered as motive in this case. And we brought that up at the trial court level when we were arguing at the sentencing phase of this, that, our thoughts as to whether that was misconduct or not. Any other questions? All right. Thank you, Your Honors.
Consider case 20-1173 submitted, and we will issue a written decision in due course. Thank you, counsel, for your arguments today.
All right, let's get rid of this. I'll bring this up. So this is the appellate decision, which they affirmed his conviction. Essentially, it has more to do with the fact that the evidence that Todd on the stand says that he agrees that it was murder, even though he's not really agreeing with it. So, facts and prior proceedings. Todd was passionate about farming. He loved farm life and worked very hard. Todd purchased his first farm in 1999. Eventually, Todd's operation grew to 3 farms and part of another one. Todd's farm includes 2 hog barns on his home place. Todd met Amy in 2003 at the Delaware County Fair. They married in 2004. Following the marriage, Amy moved on to Todd's farm. However, Amy worked off the farm in healthcare. Eventually, the couple had 3 children, but they all also had their challenges. Around 2013, Amy had an affair with someone she had met through work. They still won't let us, they still don't want to tell us that this person was a deputy. The couple entered counseling at the encouragement of a mutual friend and reconciled, and Amy left her job and became a stay-at-home parent. Amy had to be accountable to Todd and let him know if she had to go somewhere. I think that's an odd statement, but whatever. According to Amy's stepmother, Todd resolved to work things out and told Amy's stepmother, "I'm not going to lose my farm and what I've worked for." Things came to a head in 2018. The year was full of difficulties. In June, Amy began a second affair. Yeah, she's so accountable for her locations. This time with Jerry Frazier. They have no problem naming him, though, who oversaw the farm's hog operation. Todd became suspicious of the two after reviewing a phone bill and noting a significant amount of contact between Amy and Frazier. So Todd confronted Frazier, who denied the affair, but Todd was unsure whether Frazier was telling him the truth. So Todd contacted Frazier's wife and shared his suspicions with her. She thought Todd was a little crazy. Todd called back a couple of days later and apologized to both of them. He also shared his suspicions with Amy's stepmother. And Todd questioned their mutual friend, Amy's former coworker, about Amy's behavior and indicated she was acting like she had during her first affair. At one point, their friends suggested the two might be better off not together. But Todd responded, "I have worked for this farm since I was 11 and I will not give it up." When their mutual friend learned of the affair from Amy, she told Amy, "You're putting yourself in a really dangerous situation," and expressed concern, stating, "Todd is going to kill you," because Todd is just the person you don't mess with. Such a tough guy. Big Todd, you don't mess with him because of all the examples they gave us of why, which was zero. Their friend was at a work event and heard rumors of the affair, so she told Amy about the rumors, and Amy became upset, and Amy then told her where to look for her body should she go missing. Amy contacted another former coworker to see if she had heard rumors of the affair and asked her to stop any that she might hear. The lady that they're referring to here was like, "I didn't even really know Amy. I don't know why she called me." High streets. Amy explained several times that Todd would kill her if he found out, and explained her oldest child, Tristan, had told Amy, "If Dad finds out you're going to have an affair, he'll kill you." What a weird thing to say. If you're going to have an affair, he'll kill you. Hi, Tia. By July, Amy had talked to their mutual friend about leaving Todd, and Amy, quote, was to the point where she felt like she was strong enough to leave on her own, and it was not so much anymore she would leave for Frazier, but she would leave on her own. Amy, which obviously not, since she's wanting to hide the fact that she's having this affair, and then she's over here going, "Oh, I'm not leaving you, Todd. Everything is wonderful. Everything is great. You know, there's these rumors. Please don't believe them. If I'm leaving you, what the hell do I give a shit?" Amy said she was quietly looking for jobs and somewhere to live. I would love to see if she actually had any of those searches. Any job searches, any searches on places to live. Nobody ever talked about that. That'd be interesting to know. Yeah, Foghorn Terry. That same month, Amy explained to another friend that Todd did not want a divorce because he would lose half of everything, and it is socially unacceptable. On another occasion, Amy explained to her that she was scared of Todd, and if he found out about wanting a divorce or an affair, that he would kill her. Then Amy's grandmother passed away in August, which they keep saying August, but those texts were from July, so I don't know why that's weird too. According to Amy's brother, by then Amy was planning to divorce Todd and expected Todd to, quote unquote, flip out. But Amy was worried that Tristan would be angry with her for leaving Todd. Amy asked her brother to store some of their grandmother's furniture so that she would have some when she left Todd. At the end of the month, Todd confided in their mutual friend and explained Amy told him there were rumors about her having an affair, and then she cried for hours and said she should leave because we are better off without her. Okay. In October, Amy's uncle suffered a brain bleed, so Amy was away from Todd and the children frequently to help with her uncle's care, and her absence began to wear on Todd as he had hogs going out plus the harvest and had to care for the children at the same time. That month, Todd found a corn rake in the yard and put it in the red shed. He just found a corn rake in the yard and put it in the red shed. That's not really what happened. It was just out there. He had actually gotten it years before at the farm across the street that he had purchased. Amy had an outpatient medical procedure on November 6th. Upon discharge, Amy had a 10-pound lifting restriction and rested at home for a few days. A friend texted Amy the morning of November 10th to see how she was doing, and Amy responded, "Thanks, okay, things still very tense around here. Just not sure of anything anymore." And so she said the footnote is that the couple's mutual friend described the procedure as an ablation. That morning, Tristan and Todd had left the house to check on some hogs off-site. Then they returned to the farmhouse for breakfast that Amy had prepared. After breakfast, Tristan and Todd went out to the North Hog Barn on the farm. The barn was as large as a football field. At 10:12 a.m., Amy emailed Frazier, "Do you know what I'm doing today? cleaning fucking light fixtures in the barn. What the fuck? A few minutes after Tristan and Todd went to the North Hog Barn, Amy came out to join them. They worked to prepare the barn for incoming infantile hogs. Todd was arranging nipple feeders in the pens, Tristan was bringing heaters from a storage area to the pens, and Amy was cleaning light fixtures. Amy cleaned the fixtures while standing on a 5-gallon bucket, and Tristan and Todd noticed Amy seemed unsteady, and both asked her if she was all right. Amy continued to work, but still appeared unsteady, so both Tristan and Todd suggested she stop working on the light fixtures. Todd suggested instead Amy could go get a pet carrier from the red shed, which was about 30 yards from the front of the hog barn. The pet carrier weighed about 10 to 15 pounds. And now this lady at this appellate hearing is saying that it was like 15 to 20 pounds to make it even. Oh, it's so much worse. Okay. Todd asked Amy to either take the pet carrier to their shop building across the yard or leave it out for them. Tristan and Todd continued to work in the hog barn for about another hour and a half. After Amy left, Tristan took over cleaning light fixtures. At some point, Tristan lost sight of Todd while they were in the hog barn, but was unsure of how long that was. Now, he was fine with how long it was, and then they convinced him that he was unsure. Tristan was out of Todd's sight when he stepped into a small office in the corner of the barn to get a drink of water a couple of times. When Todd noticed the pet carrier was not in the yard or in the front of the shop, he sent Tristan to get the pet carrier out of the red shed. This is another big thing. They cannot get the story straight on, did Todd send Tristan to go find his mom, or did Todd ask Tristan to go get the pet carrier where he happened to find his mom? This makes, like, they cannot figure that out. And that seems to be a really big deal when the state is sitting here saying how, he purposely had his 13-year-old son go find his dead mother, blah, blah, blah. Hi, Chelsea. Hey, see you, Mama. Yeah, because you never find random shit in random places on a farm. Ain't that a fact? Okay. So Tristan went into the red shed and found Amy on her hands and knees, face down with the corn rake sticking out of her back. Tristan yelled for Todd. Amy was unresponsive. Tristan checked whether Amy had a pulse or was breathing. Todd ran over and told Tristan to get the truck and bring it over. Todd did not render aid or call 911 while he waited for Tristan. When Tristan brought the truck over, he saw Todd pull the corn rake out of Amy's back. Tristan got in the passenger side of the truck, and Todd put Amy on Tristan's lap, and they set off for the hospital. While driving, Todd called 911 at 12:01 p.m. and said Amy fell on a corn rake. The operator told Todd to pull over and perform CPR, which Todd did. Deputy Luke Thompson arrived on the scene and took over CPR. He asked Todd what happened, and Todd told him that they found her with a corn rake in her back. An ambulance arrived on the scene, as did some bystanders who knew the family. Tristan went back to the family farm with one of the bystanders. Todd went with another bystander and followed the ambulance to the hospital. At the hospital, Amy was pronounced dead. A medical examiner completed an initial examination of her remains and discovered 6 puncture wounds on her back. The medical examiner also observed injuries to Amy's chin, cheekbone, knees, and knuckles of each hand. The injury to Amy's chin had both crush and scraping components to it, but there was no debris in the wound from hitting a surface. Because Todd reported that Amy fell on the corn rake, the medical examiner asked to see it. When the examiner discovered the rake had 4 tines, he questioned how it would create 6 puncture wounds with 1 impact. So he contacted the state forensic pathologist and requested she perform an autopsy of Amy's remains. Meanwhile, deputies followed Tristan back to the family farm, where Tristan showed them the red shed and where he found Amy. That evening, Delaware County Deputy Sheriff Travis Hemisath was briefed on the case by Deputy Thompson, who took Deputy Hemisath out to the family farm to investigate. 2 days later, Deputy Hemisath attended the autopsy performed by the forensic pathologist. The forensic pathologist determined the damage to Amy's left hand could be defensive wounds consistent with a struggle, and that she had blunt force trauma to her chin, cheek, and ear. When examining the puncture wounds to Amy's back, the pathologist discovered 2 different wound paths, so the pathologist reasoned Amy was impaled with the corn rake at least 2 times and possibly 3 times. And the pathologist found the corn rake penetrated through Amy's back deep enough to rupture her breast implant and exit her front side, as well as puncture her lung and liver. So the pathologist classified Amy's manner of death as a homicide. As a part of his investigation, Deputy Hemisath executed a search warrant. This guy's such a douche nozzle, you guys. I can't even say his name without just thinking of what an idiot he is. Hi, Mav. Executed a search warrant and took all of Todd's electronics, including a camera system with 2 cameras covering the property. No video from a camera pointed at the red shed could be recovered, and video from the camera pointed at the yard between the buildings spanned September 11th through October 29th and then picked back up on November 11th. Through the day, the camera system was confiscated, but investigators could not determine if the missing video was deleted. Deputy Hemisath also collected Todd's iPad that was located in his tractor at the time. He did not, okay, he didn't really collect it, they brought it to him. Deputy Hemisath discovered that earlier in the year, the Google account Todd used on his iPad was used to search for things like, did ancient cultures kill adulterers, thrill of the kill, thrill of the hunt, famous quote, no thrill like that of hunting man. Once you hunt man, you will always feel the thirst. What happens to cheaters in history, killing unfaithful women, what to do with large open chest wounds and organs in the body. Let's see what that footnote is. We acknowledge other family members had access to Todd's iPad and knew the password. No, Travis Hemisath did not. He did not acknowledge that. He was very adamant on the stand that that was Todd's and all of Todd's searches. But a rational jury could find Todd was the one who performed these searches. Oh my God. I love how they left out the wedding rings and the wedding dresses. Following the autopsy, Deputy Hemisath contacted John Turbot, a special agent with the Iowa Division of Criminal Investigations, to assist in his investigation. Special Agent Turbot investigated Frazier, with whom Amy had had the affair, and eliminated him as a suspect in a conversation that happened in a car that is not recorded or videotaped. We have no idea. Special Agent Turbot also eliminated Frazier's wife as a suspect. Special Agent Turbot then interviewed Todd. Todd described his marriage to Amy as great and said that they had a very healthy marriage. Eventually, Special Agent Turbot confronted Todd and accused him of killing Amy. Todd responded by asking what evidence he had and asked Turbot to tell him what the police knew. Yeah, that is a very bad paraphrasing of that conversation. That is not really what happened. He told Special Agent Turbot, "You want me to confess to something I didn't do." During the interview, Todd was unemotional and very flat. Eventually, Todd was arrested for Amy's murder, and the matter proceeded to a jury trial. Todd moved for a judgment of acquittal following the state's presentation of evidence, contending the state failed to present evidence. Todd committed the act that killed Amy. Todd testified in his own defense. During cross-examination, Todd conceded that Amy's death was not an accident, and someone stabbed Amy in the back with the corn rake 2 or 3 times. Todd renewed his motion for judgment of acquittal following his presentation of evidence. The jury convicted Todd of first-degree murder, and Todd motioned for a new trial, which the district court denied. Todd appeals, claiming the district court erred when it denied his motions for judgment of acquittal and abused its discretion in denying his motion for a new trial, which, because his conviction was not supported by sufficient evidence, additional facts will be discussed as necessary. So, the principles governing our review of a district court's denial of a criminal defendant's motion for judgment of acquittal are well established. A motion for judgment of acquittal is a means of challenging the sufficiency of the evidence, and we review such claims for correction of errors at law. And that's just a bunch of repeating of that. The weight of the evidence. So we first addressed Todd's contention that the district court erred in denying his motion for judgment of acquittal because the state failed to present sufficient evidence to support his conviction. Todd generally attempts to poke holes in the state's case and essentially attempts to retry the case for a different audience on appeal. But those efforts are futile. It is not for us to independently weigh the evidence to reach our own conclusion as to Todd's guilt. Instead, we proceed by viewing the evidence in the light most favorable to the state to determine whether it presented substantial evidence of Todd's guilt, evidence that a jury could rely on to find Todd guilty beyond a reasonable doubt. In doing so, we break down the offense murder in the first degree element by element, whereas here the jury was instructed without objection. The jury instructions are the law of the case for the purposes of reviewing the sufficiency of the evidence. The state must prove all the following elements of murder in the first degree: that on or about the 10th day of November 2018, the defendant committed an act upon Amy Mullis. That number 2, Amy Mullis died as a result of the act of the defendant. Number 3, the defendant acted with malice aforethought. Number 4, the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Amy Mullis. So on appeal, Todd attempts to challenge sufficiency of elements 1, 2, and 4 of the marshalling instruction. But the state contends Todd only adequately preserved error as to the first element, identity. To preserve error on a claim of insufficient evidence for the appellate review in a criminal case, the defendant must make a motion for judgment of acquittal at trial that identifies the specific grounds on the appeal. So we must first consider whether Todd adequately identified specific grounds related to each of those challenged elements in his motion for judgment of acquittal before we may consider them on appeal. So they go, essentially they're going to go through each one of those elements and see if the state had any evidence that supported them, a jury being able to find him guilty, which ultimately, yes, that they do, because there's no counterpoint for anybody to consider, because the defense attorneys literally brought no evidence to trial to say this is the other possibility of what happened. So with respect to the first element, we agree with the state that Todd adequately challenged identity to preserve a challenge to the first element. With respect to the second element, Todd now claims Amy died as a result of a tragic accident, not as the result of another person's actions. But Todd never argued this ground when making his motion. Instead, Todd's counsel conceded Amy died obviously as a result of criminal behavior. That was his original counsel. So footnote, Todd claims that he never authorized his counsel to make such a concession, seemingly assuming this will permit him to argue that Amy died as a result of the accident on appeal. Even if that were true, Todd himself conceded on cross-examination that someone killed Amy, and the evidence presented at trial established Amy died as a result of intentional conduct, not a tragic accident. Moreover, she had defensive wounds on her hand, her chin. They're not defensive wounds, but absent of any debris, was consistent with being struck, which should say struck, by someone as opposed to falling into something. And the corn rake punctured her back at least 2 times. This evidence is indicative of an attack perpetrated by one person on another, not merely an unsteady person falling into a sharp object and fatally injuring themselves. Even if Todd had preserved the issue for appeal, we would conclude the state presented sufficient evidence of this element. The internet searches on Todd's iPad show was planning to murder Amy. Looking up Hemingway quotes. This is just, it's crazy to me how anything that we do can just be taken so far. I'm telling you guys, you look at my Google searches, I'm fucked. The evidence established Todd impaled Amy at least 2 times with the corn rake, went back to work in the hog barn, and left Amy to die in the red shed. From this, the jury could determine Todd's conduct was intentional and not accidental, making his conduct willful. Why does nobody bother to pay? Why does everybody just discount Tristan as like a reliable witness? Why does nobody believe him when he's telling them we don't, like, he wasn't gone? He wasn't really gone. We were together the whole time. Is it because it kind of changes to the minute and 40 seconds of I went and got 2 drinks of water? And Todd impaled Amy multiple times, necessarily giving him a moment in between blows to consider his actions and resolve himself to strike again. Impossible. There's not enough holes in the outer clothing for him to have struck, removed the rake, and then struck again. There would be all those same holes would be in all of the clothing. So you're saying that he struck her and only pulled out a couple times and struck her again with those other times. Like, make that make sense. The holes on the clothes do not match the wounds on her back. So what did he take off her jacket after the first strike and then put it back on? So the evidence is sufficient to support a finding Todd acted deliberately with premeditation and specific intent to kill. So his challenge to the second element is not preserved. With respect to the fourth element, which requires evidence Todd acted willfully, deliberately, premeditatedly, and with the specific intent to kill Amy, we do not think Todd's motion raised an adequate challenge to preserve the issue for appeal. And the obvious and understood exception to our error preservation rule does not apply. Accordingly, we limit our review to determine whether there is sufficient evidence that Todd was Amy's assailant. Reviewing the evidence in the light most favorable to the state, we conclude that there was sufficient evidence to identify Todd as Amy's attacker. Though not a required element to the offense, we recognize Todd had motive to kill Amy. Witnesses testified that Amy was getting up the nerve to leave Todd, but Todd was staunchly against divorce because it would put his cherished farming operation at risk. These are all Amy's little gossip friends that are saying that. It's all hearsay based off of what Amy has said, essentially. Todd says, like, I'm not losing my farm. I worked on it since I was 11 years old. Well, he wasn't going to lose his farm. So I don't know what the issue was. He was going to stay at the farm. She was leaving. The state also presented evidence that Amy, Tristan, and family friend believed Todd would kill Amy if he learned of her affair. And once again, this is all based on fucking Amy. And rumors were running through the community. Todd admitted he was suspicious of the affair even after he confronted Frazier about it. The jury could have reasonably concluded that Todd learned of the affair, Amy's plans to leave him, or both, and resolved to kill her either in an act of vengeance or as an attempt to avoid divorce and preserve his assets. From the evidence presented, it was clear that either would serve as strong motivation for Todd to act. Indiana girl. Oh, shit. Getting down to brass tacks, only Todd and Tristan knew Amy would be in the red shed when she went to move the pet carrier. Tristan never left the hog barn. But he did lose sight of Todd while they worked. And Tristan could not say how long Todd was out of his sight. The two youngest children were inside the home the entire time. How do we know that? There's no cameras proving that the two youngest children are inside the home the entire time. And if Tristan can't see Todd, guess what that means? That means that Todd can't see Tristan. So you literally, and we also have all this evidence, since it's what we want to call it, from Amy's hearsay mouth, that Tristan was going to be mad at her and that Tristan refused to get on the bus because he figured she was going to be gone when he got back. And that Tristan knew she was having an affair. Both, so, I mean, testified that no one else on the farm that day, and Todd never heard anyone drive onto their rural property. So there are no other potential assailants. Todd argues it would be impossible for him to run 50 plus yards inside the hog barn, exit a double latch door on the east end of the barn, sprint 150 yards to the red shed, murder Amy with a corn rake, and run back in time it took Tristan to get a drink. But Todd's argument rests on a faulty premise because Tristan could not say how long Todd was out of his sight. Tristan said he wasn't out of his sight. And then he said, well, I got 2 drinks of water. One can infer or can concede how long it would take to get a drink of water out of a hose. And no matter whether you think he took a really, really long drink or a really, really quick drink, it's still not enough time for Todd to go all the way around this building, get into the red shed, kill her, hitting her multiple times, run all the way back in there, get back to work, act like nothing's going on, and be like, all right, Tristan, how was your drink of water? There's not enough time. So even if he's like, I can't guarantee you it was 1 minute and 40 seconds, it could have been 2 minutes and 5 seconds. It could have been 1 minute and 20 seconds. It's not like he's saying it's 1 minute and 40 seconds up to 2 hours. Like, we're just being silly. Criminality, tell what Paul said. He was told Tristan was told by the family lawyer on the live the other night. I don't. You're going to have to refresh my memory. Give me a little something so it can trigger my memory on that. This provided a window of opportunity for Todd to slip out of the barn while Tristan worked. Wait, no. That is no, that's not that statement is absolutely inaccurate. This provided a window of opportunity for Todd to slip out of the barn while Tristan worked. No, while Tristan took a drink of water is the only time Tristan said that he wasn't that Todd wasn't in his sight. So Tristan wouldn't have been working. Todd relies strongly on Tristan's testimony that Todd did not appear winded or upset when he saw him again. Here, young Tristan was just in 8th grade, so now he's an idiot because he's an 8th grader. And my daughter's in 8th grade. If I was gone for an hour, I guarantee you she's the one that would know it. She would know exactly how long I was gone, probably more so than my husband. She's like a tracker of me. I agree, Soulshine. Okay. Todd relies strongly on Tristan's testimony that Todd did not appear winded. Okay, here, young Tristan was just in 8th grade. Just a young, dumb kid when he testified at trial almost a year after the events in question. His initial statement was that him and Todd were together the whole time. Given his young age and the trauma he no doubt experienced as a result of this incident, no one would expect him to remember the day with perfect recall. This is nuts. Oh, yeah. Okay. So, yeah, well, because they're going to hold him to that time frame is kind of what I took from that. So if I'm misquoting it, Indiana girl, please let me know. Maybe Paul will stop in today and tell us again. But it was, the attorneys were telling Tristan, would your daughter rat you out if you killed your husband? If I killed my husband, probably. She'd probably rat me out. Yeah. Yeah, she does. She likes that guy. She likes her dad. I don't know. I don't know what kind of taste she has, but now if it was somebody else, I don't know. She might have my back. So the attorneys were telling Tristan like he couldn't say a concrete time because he could end up in trouble with saying an incorrect time. My Kaylee wouldn't rat me out. If it was my husband, she'd rat me out, or her siblings. I'd definitely get ratted out for that. I can guarantee there's a few people that she'd have my back with. She's my little partner in crime. Yeah, she's a mommy's girl. She's a daddy's girl too, but she's a mommy's girl. The little one, my tiny human, is really a daddy's boy. He likes his daddy. Okay, here we go. Given his young age, and juries are free to weigh the credibility of witnesses and believe some, all, or none of a witness's testimony. So Tristan's testimony about Todd not appearing winded or upset is just not dispositive. What is clear from the evidence is that only Tristan and Todd knew where to find Amy when she was attacked. She's not attacked. Todd had ample motive to harm her. Tristan never left the hog barn, and he lost sight of Todd while they worked. Other than the younger children, there is no evidence anyone else was on the farm that fateful day. And from the evidence presented, Todd is the only possible assailant. So we conclude the state presented sufficient evidence that Todd was Amy's attacker, and the district court properly denied the motions for judgment of acquittal. So motion for a new trial. Todd also claims because there's insufficient evidence to support his conviction that the district court necessarily abused its discretion in weighing the evidence and determining the weight of the evidence supported the conviction. From the get-go, we disagree. As previously discussed, there was sufficient evidence supporting Todd's conviction. When ruling on the motion for a new trial from the bench, the district court stated, I would say I think that I'm actually required, or at least that I should independently weigh the evidence and consider credibility as it pertains to a motion for a new trial. If the verdict is contrary to the weight of the evidence, the defendant is entitled to a new trial. I cannot say that the evidence in this case or that the verdict is contrary to the weight of the evidence, because his defense attorney did nothing to knock any of that evidence down, besides the Hemnasath who doesn't know what the fuck UTC is. Basically, after the depo, his lawyer, who was paid by her family, that he needed to be careful what he said or he could end up in juvenile prison. Presumably, maybe he did. Maybe he did it. Yeah. they didn't do any, they didn't do any cell tower checks. They didn't check her fingernails to see if there was anything. They say that she's in this altercation with whoever, with receiving these defensive wounds. Todd doesn't have any wounds. Jerry Frazier doesn't have any wounds. So why wouldn't they test the fingernails to see if anybody else's DNA is under there? It just doesn't make sense. Okay. So they say, nope, your conviction stands. No new trial. Too bad. So sad. Go back to prison, Todd. So then we get to the post-conviction relief hearing. So finally, he gets a team of attorneys, one independent who gets a team of attorneys from the Innocence Project to look at Todd's case. They file for post-conviction relief, and they are granted a hearing that takes place just a couple of weeks ago. So first things first, I'm going to play you guys a clip of one of our fave defense attorneys who represented Richard Allen, who was interviewed on Law and Crime regarding post-conviction relief and what his thoughts are on Todd Mullis receiving post-conviction relief. So it's just an ironic interview with where Andy falls in line with Richard Allen's case in Delphi to where Todd Mullis now is in his path of freedom.
Ensure that a just trial had occurred already and find that his
Counsel.
Joining us now to talk more about what we could see and how we got to this point is criminal defense attorney Andrew Baldwin. Thank you for taking the time to be with us today. First off, this civil bench trial that's taking out, how common is it to have a process like this play out that could potentially lead to a new trial?
Oh, it's the last resort, Chris, for any defendant that has exhausted all their appellate processes that are out there. This is throughout every state, it's very, very common to get to this point in terms of asking for the hearing. Now, what's a little bit more unusual, or a lot more unusual, is actually getting the hearing. And most, maybe 99 out of 100 times, the judge just denies these things without a hearing. Often, if they do have a hearing, it's pretty rare.
What does it tell you about
right
this?
There. To even get in the court to have a post-conviction hearing is incredibly rare. And it's Todd's last-ditch effort. This is it. There ain't nothing really that can happen after this to overturn his conviction. If this judge does not give him a new trial, he just goes back to prison, and I don't know if there's really legally anything else that can happen after that. So, and he's talking about how this is incredibly rare to ever even get this hearing.
This case that it was actually granted, that they now are going to have this 10-day hearing with 40 witnesses expected to testify?
Well, it means that it may mean at least that the judge thinks there's actually something there, and that it's worth looking into. Because especially most PCR hearings is what we call it, post-conviction relief hearings. They last, maybe an hour, maybe 2 hours. But when it's 10 days, I've never seen anything that long before. So that's a lot of time to take out of a judge's calendar. And especially when it's being aired live and so forth, it might be a good sign for the defense that the judge thinks that something might be there worth looking into.
So we do know that it doesn't end up lasting 10 days. What it does, it lasts 6 days. So we have 6 days of post-conviction relief testimony.
Let's dive into some of the parts of this case that have been up for debate. And one of the big ones is Todd Mullis has said the defense that he was given by his attorneys in his first trial was not what he wanted. His defense attorney said that Amy was murdered. And he says he never admitted that was the path that they were going to go, that he still believes that she was the victim of a farming accident. What do you make of that dynamic that he's argued now for a couple of years?
Yeah, it's difficult. People don't understand the shoes of a defense lawyer until they step into them. And there's some difficult decisions that need to be made as defense lawyers. It is, for the most part, you're on the same page with your client. but every once in a while, the client just wants it done a certain way. And you as a lawyer have to make a decision. What people don't know is the client does not get to make that decision about the strategy moving forward. The client gets to make a couple of decisions in the course of a case. Number one, do I take a plea? Number two, do I take the stand? And between those two things, the attorney doesn't have any ability to say no. However, when it comes to strategy, the lawyer, they have the full say. You want to try to get along with your client during the course of the case, but sometimes you have to go a different direction. It's pretty rare, but it does happen. And I think one of the problems I think going on in this particular case is on the opening statement that I watched for this PCR hearing that's going on right now. The prosecution said that on cross-examination during the actual trial back in whenever that was a few years ago, that the defendant Mullis actually said, I think this is murder on cross-examination. This is not an accident. And that could be problematic trying to explain that away, especially when he's under oath.
For you, if you were his counsel going back to the original trial and he said, I want to go with the farming accident defense, as opposed to saying that she was murdered, what would you have said in those conversations?
Well, my law firm would have probably gathered everybody, lawyers and staff and receptionists and everybody into a room and looked at the evidence and said, does this work? Which way does this play? Because we'd like to honor what the client wants, but if it's so far-fetched and ridiculous, then you don't want to do that. So you like to get all kinds of people and their opinions in play. One of the other things going on here that I thought was interesting when I was watching some of the original trial testimony is, I don't know if it was the coroner or the forensic pathologist, but somebody got on and they said, well, when it was explained to you that it could be a fall from a pitchfork, what was your thoughts? And he said, it didn't seem likely to me. Something along those lines. It was very non-committal versus what it could have been, which is, there's no way that was a fall onto a pitchfork, or there's no way it was an accident. And that makes me think that just that alone makes me think that there was some life to the accident theory, and maybe it should have been checked out. But again, I don't like playing Monday morning quarterback with lawyers. I don't like that when they do that to me. But now that they lost, you probably ought to have gone with a different defense.
Because he loses or is found guilty in the original criminal trial, loses his appeal. How much, in listening to the opening statements today by his attorneys, it did sound some of the similar arguments that he's made since he was convicted, that he didn't have a chance to have the defense that he wanted, and some of the other concerns that he had. In these type of hearings, I mean, how much more evidence do you need to bring to the table that is different than what you've said in the past if you've already exhausted all your other appeal processes?
You need to bring significant evidence, I think. I mean, one of the things that is interesting, I will applaud the trial lawyers for doing this. In fact, one of the pieces of evidence from my understanding is these lawyers that did the trial, they have conceded that they were ineffective, almost. That they should have looked into expert witnesses, that the expert witnesses, should they have looked into them, would tell a different story, that an accident was in play. And so that is one significant piece of evidence, is the trial lawyers falling on the sword, so to speak, and saying, yeah, we were ineffective. We should have done something different. But then you have to back that up with the evidence that they should have put in to play at the trial. And apparently that's going to happen here. And you better have some very good expert witnesses coming on and saying, yeah, this was definitively an accident, or could have very well been an accident. And that way the ineffective part of the claim becomes even more important.
I want to get your take on this infamous 911 phone call. And during the CPR compressions, the prosecution was able to tell the jury and confront him and say, did you call? And I can't really say it on air, but ultimately calling his wife a cheater under his breath as he was doing chest compressions. I've listened to that recording multiple times. I can't seem, and maybe for other people, they can hear it. I can't seem to hear it myself. What did you hear?
I didn't hear anything. It bothered me that the prosecutor was able to voice the words of what she thought that she heard. I don't know if there was a motion in limine preventing the prosecutor from putting that out there for the jury to hear, because sometimes once you hear something, then you cannot unhear it, and you start to think that, is that what they said? And I think in my opinion, it's inappropriate.
Isn't that ironic? Isn't that ironic? Because he's like, I've lived this, sir. I know what I'm talking about.
For the prosecutor to put that out there, it should have just been, what did you say here? And he says nothing. And then on closing arguments, the prosecutor then can say, here's what I hear. And I thought that was inappropriate for the prosecutor to have done that, unless it was ruled upon by the judge pretrial. But I didn't hear anything. I didn't
either. And I really tried to listen to it, and I couldn't hear it myself. Even when I told my mind to try and listen for it, I couldn't. Is that something that could come into play in this hearing, that was actually allowed in front of the jury?
I mean, again, I don't know much about the pretrial rulings, but yes, it should be. I mean, that's crazily damaging stuff to hear. If the prosecutor, again, puts into play what she thinks that she heard, that's not good. And if the defense lawyers did not file a motion in limine to prevent that from being said, then that goes toward their ineffective claim.
One other piece of evidence that stuck out that the defense's attorney talked about in their opening statements today were some of the internet searches that Todd Mullis apparently made leading up to this incident and Amy's death, where he was very angry about the infidelity that she had in their marriage, and something along the lines of saying, what happened to cheating people in ancient times. But then the defense today argued that this was in a house where there's preteens, they had kids around. And maybe the defense in the original trial didn't push back on the fact that there were all these different people around. How could that come into play? Is that something big enough that could actually make a difference in a hearing like this? That the argument was that maybe he didn't do it himself when he's denied making those searches.
Yeah, I think it could have some minor impact on the ineffective assistance of counsel claim if his trial lawyers did not bother to make those types of arguments that, hey, there's 3 different kids or how many ever other people had access to the computers, and they didn't get into that kind of nitty gritty. I mean, these Google searches are incredibly common nowadays for defense lawyers when they're in trial. And those are the kind of the go-to arguments, is who had access to the devices. And if the trial lawyers did not make those types of arguments during the trial, then it could go toward the ineffective assistance claim. I view it as kind of minor league stuff compared to the other things that they're talking about today. The expert witnesses that are apparently going to come in and say that this looks like an accident. That's the big league stuff. The other stuff related to the Google search is probably more minor league.
Because in speaking of some of the big league stuff, I mean, there was, this now infamous corn rake that has 4 prongs. There were 6 holes in Amy's back. How, if you were a defense attorney on this case, how can you argue against it being something that was taken out, then put back in, and say it was an accident when there's 4 prongs and 6?
Well, I mean, I've thought about that since I read about the case and watched one of the videos that one of your colleagues put together on it, Jesse. But I would think that one answer would be potentially that, did she fall on it, reach back, it seems preposterous maybe, but reach back out while she's on the ground and then fall back on it. That could be something that is, you throw out there in an argument. But what's confusing about it is, how would there be 6 prongs if you would think it'd be 4 or 8 if it was, unless it just magically hit 2 of the holes again. So I would have to know more about it and look at the photos. And these are the types of things where you win and lose cases, is by brainstorming with people in your firm that, hey, what could have happened? There's a thing called psychodrama that we utilize from time to time, where you kind of put yourself in the shoes of what might have happened, and then you can really magically come up with, whoa, okay, I can see what theoretically might have happened. It may seem a little bit far-fetched, but it's something. And so that it's hard to answer that question about how you would
Sure.
explain it away. You'd want to work in conjunction with your expert witnesses, but also your team that you have working with you, trying to come up with a game plan that makes sense and passes the laugh test in front of a jury.
Yeah, the laugh test is really important. This will eventually be decided, at least this phase of it, of whether there's going to be a new trial. It'll come down to the judge. Just for you, as we've gone through the bullet points of what's happened since that day in 2018, and then now previewing 10 days of dozens of witnesses. I mean, how strong of a case does he have to potentially get a new trial in your experience seeing these kind of PCR hearings and how they play out?
I think it really depends upon the strength of the expert witnesses for the defense. If they come in there and say, my gosh, this was, I've seen this before as an expert, here's an explanation for the way that it could have happened. And then you have to link that up to the ineffective assistance of counsel claim. And so the stronger the witnesses are for the defense, the expert witnesses especially, and I don't know what other type of fact witnesses they have out there, but the stronger those witnesses are, then the more likely it is that the judge might say, you know, I do think that these lawyers dropped the ball on this big time. And it's helpful, again, that the lawyers are cooperating and kind of owning what they've done or didn't do that they should have done.
For 40 witnesses, I mean, that's a lot. Sometimes there's too many witnesses in cases like this where it's just hard for a judge, even a judge, like not just a jury, but a judge to actually remember the key points of it. Yeah.
Oh yeah, definitely. I mean, those are decisions that trial lawyers have to make every day. Am I being too redundant? Is this too complicated? And you know, I always tell the lawyers in my firm, find the most simple explanation that's easy to understand, but the most powerful. So if the most powerful argument requires 8 witnesses to kind of establish why it's powerful, but the second place argument is a one witness, you only need one witness to get that explanation out, then maybe that's the lead is the one witness. You know, you hope that a judge has got the ability to write down information, but you're right. You're totally right, Chris. Judges, they're human beings and they get distracted. They've got other things going on in their courtroom. They're getting things on their computers while the hearing's going on about somebody requesting a continuance, and they may miss important moments in time. So you want to try to make it as simple as possible if you're able to. But if you need 40 witnesses, because this is going to be your last hurrah, so you better bring the goods would be another way to view it. And if it takes 40 witnesses, it takes 40 witnesses, and you just better have a really terrific summation, a final argument at the end to highlight those important points.
Yeah, and to your point, I mean, it really, all of this, you know, as we preview the next couple of days, it comes down to the quality of those witnesses, and maybe 40 is what it takes. I mean, certainly it's a fascinating story to play out, has been for many years now. Andrew Baldwin, criminal defense attorney, thanks for joining us. We appreciate it.
Thank you, Chris. Appreciate it.
All right. So this somebody asked when this interview was. This interview was from February 24th of 2025. Okay, so now we're going to head into day 1 of post-conviction relief hearing. Let me see. Somebody in one of the groups had put together. Let me see. So like we can, if you have questions about like the who's who of his defense team. So Laura Parrish is the judge, and then this is very nice of them to put this together for us. Tweedledee and Tweedledum. Tweedledaddy is what they named the prosecution. Oh shit! Whoever did this is so my people. I love it. So his attorneys are Tara Thompson, Erica Cook, Dina Rayleigh, Elena Steenson, and then we have Tweedledee, Tweedledum, and Tweedledaddy, Scott Brown, Joshua Duden, and Thomas Bakke. When you start it, you will see the kids and the adults. Wonder who the adults are. Assume kids are Taylor and Wyatt. Yes, all 3 of his kids are there in court, including and his parents. Yes, that's Wyatt. There's Taylor. That's Todd's parents, and I can't tell if that's Tristan or not, but it probably is. All right, are we ready? That's what's her name? Oh my gosh, you guys, what's her name? What's her name? Why can't I think of her name? From like 48 Hours. What's her name? No. Why can't I not think of her name? Okay, you're gonna see her. This is Wyatt right here. This is Wyatt, the youngest kid, the one that was about 8-9 years old at the time. Okay, you're gonna see her. You're gonna notice. You're gonna know who she is. I just can't, for whatever reason, think of her name. This is the daughter, Taylor. This is Todd's parents. I think this might be Tristan here, but give me a second and let me see. And prison's done him pretty well. He looks yoked.
Good morning. We'll go ahead and go on the record. In Delaware, PCCB 009057. Todd Michael Mullis versus the state of Iowa. Mr. Mullis appears in person this morning together with his counsel. I believe the first thing that we need to address is the applicant's motion in limine.
Aaron Moyer.
There are, I believe, 4 points. Is there any resistance on behalf of the state?
Good morning, Your Honor. I'm just taking a look through it again.
That's what it is. It's Aaron Moriarty. Aaron Moriarty from 48 Hours. This one. Let me see. I'll show you. Her. This one. That's who's sitting behind the family. Spuggies. Yeah, that's who it is. Aaron Moriarty. Thank you.
And just to make sure, but I don't believe we have any resistance on that, and we would join the motions as well. Obviously, any undisclosed testimony from their experts, hearsay, things of that nature, we would agree that the rules of evidence and civil procedure control on that.
Thank you, Mr. Bakke. The applicant's motion in limine then will be granted in its entirety. Counsel for the applicant, did you desire any further record on that motion for any reason?
No, Your Honor. Ms. Erica Nichols-Cook on behalf of Mr. Mullis today, for ease of the court reporter, we don't need an additional record.
All right, thank you, Ms. Nichols-Cook. Any other preliminary matters then that counsel wishes to address? Ms. Nichols-Cook?
Your Honor, we briefly talked off record about some exhibits. Still talking to the state about that, and we will update the court on the next break. And I think we would request to do a short opening statement, but we don't have anything else preliminary.
Any preliminary matters?
That's Wyatt, the one right next to, that's Tristan, right next to Wyatt. So it's Todd's parents, Taylor, Wyatt, and then Tristan.
Matters that the state wishes to address?
No, Your Honor, I would agree with that recitation of our understanding.
Okay, Ms. Nichols-Cook or one of your co-counsel, if you're ready to proceed with your opening, you may do so.
Yes, Your Honor, Ms. Thompson's going to do the opening.
Ms. Thompson, whenever you're ready.
The blue plaid is Tristan.
Your Honor, with the court's permission, I'll stand just for this opening portion
Right
of the.
Right there. That's Tristan. Tristan, blue plaid, white plaid. This is Wyatt, and that's Taylor, and that's Aaron Moriarty. This is Tara Thompson. She actually does the majority of this. So what I did learn when I went on with Fish the other night and Paul is that the lady sitting here is Dina. She's the one who was on the 48 Hours episode a few years ago. apparently what they did was like have like a mock thing with like prosecutors and defense attorneys. And then she ended up taking on the case for post-conviction relief. And she assembled this entire team of attorneys for his post-conviction relief matters from the Innocence Project. Yeah, crying is Wyatt. Tristan is the one who testified and was working out in the hog barn with him.
Proceedings today.
Certainly.
Good morning, Your Honor. Todd Mullis has always believed that his wife, Amy Mullis's death was a tragic accident. He always believed this because he was on his family farm the day that she was injured. He was there right after his son, Tristan, found her. He was there as he and his son, Tristan, tried to give Miss Mullis emergency aid and rushed her to where EMTs could get her to the hospital. He was there when first responders treated her injuries like they were the result of an accident. And he was not aware of any information that would tell him that what happened to her was anything other than an accident. Even when police began an investigation and began to treat him like a suspect, he did not stop believing that what happened to Miss Mullis was an accident. He knew he had nothing to do with her death, and he didn't believe that there was any evidence that anyone else did either. His account of what happened and his beliefs, unlike the accounts of some of the people that you're going to hear in this post-conviction trial during this week, has always been the same. But at trial, he did not have any way to present evidence to the jury that this was an accident. And that issue is what the court's going to hear about over the course of this hearing. The court's going to hear evidence that he begged his attorneys, begged them all through pretrial preparation to investigate this case as an accident. The court's going to hear evidence that his lawyers disregarded what he was telling them. The court's going to hear evidence that his lawyers did not talk to experts or fact witnesses that would have helped them understand and present a case that this was an accident. And the court's going to hear evidence that his lawyers did not listen to his explicit direction to investigate these issues and to pursue this case as an accident. And because his attorneys did not listen to him, because his attorneys did not investigate or present these issues, the jury did not hear important evidence that they needed to hear to understand that the state's case was simply wrong. The jury heard the exact opposite of what Todd Mullis asked his lawyers to present. They heard his own lawyer in opening statements tell the jury that Todd didn't know what he was talking about, that Ms. Mullis was murdered. They heard his own lawyer, in effect, tell the jury that Mr. Mullis was not credible. They heard his own lawyer make these concessions on day one, right when this trial began, and then really have no defense to present on Todd's behalf. His lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And at this point in the proceedings, the court has heard in various pleadings at other hearings that we've had, the PCR team for Todd repeat this to you over and over again in all of the filings, that this was an accident, that this is what this case is about. And we've repeated that to the court because it's true. And it's among just the many reasons that Todd Mullis deserves a new trial and what this court is going to hear at this hearing. On behalf of Mr. Mullis and his team, we're grateful that after all this time that we're here, that Mr. Mullis is able to be in court this morning to remedy this wrong. Nobody listened to Todd at trial, but this week he'll have an opportunity to be heard through this case. And the court is going to hear other important evidence as well that the jury never heard, that is going to create at least the reasonable probability that the outcome of his trial would have been different if the jury had heard everything that the court is going to hear over the course of this trial. The court also knows that this is the rare PCR case here in Iowa with an actual innocence claim. And that is what the court is going to believe and know about Todd after this hearing. The court also knows that all of Mr. Mullis's most important claims survived the summary judgment rulings that the court made, and that the court is going to hear his claims and his evidence this week. And everything that this court is going to hear is going to establish that the underlying trial that Todd had was nothing short of fundamentally unfair. It was unfair because of the actions that his trial counsel failed to take, that any reasonable attorney would have done on Todd's behalf. It was unfair because the state withheld from Todd important favorable evidence that would have undermined confidence in the outcome of this trial. And it was unfair because the trial prosecutors did things that resulted in misconduct in how they presented the case and what they presented. And the court's going to hear evidence that makes clear that Todd Mullis was right. As we said, the court will hear that Todd's attorneys conceded right at the beginning of this trial that this was a murder. And with that sort of tentpole in the state's case, the state telling the jury and nobody disagreeing that Ms. Mullis was murdered, that resulted in a situation where there was really no meaningful adversarial testing of any of the evidence that the state presented. And the court's going to hear evidence about each of these issues this week. The court is going to hear that the state then was allowed to present witnesses giving contradicted hearsay and innuendo that painted Todd in a bad light. The court's going to hear that that evidence painted a false image of Todd, of his marriage to Ms. Mullis and his family, and that made random Google searches that were done by a family family with a house full of teens and preteens seem like evidence that Todd was planning to harm his wife. The court's going to hear the truth about those searches this week. Without Dr. Cruz, the state's main witness, telling the jury that this was a murder, that evidence is what it is, which is kind of silly, meaningless, evidence that really doesn't explain to anyone what happened to Ms. Mullis. The court's also going to hear from fact witnesses that have important details that help us understand what experts that the court is going to hear from this week are going to say, which is that Ms. Mullis's death was an accident. The court will hear from first responders and from other people through depositions and through live testimony who witnessed medical efforts for Ms. Mullis. The court's going to hear from those experts that I mentioned that are going to explain from a variety of disciplines how all of the objective evidence in this case demonstrates that Ms. Mullis's death was an accident and that the testimony that Dr. Cruz told the jury in this case was just wrong. The court is going to hear, either live or through depositions, from Todd Mullis's trial counsel. And the court is going to learn about the mistakes that they made and that those mistakes were not about strategy. They were just mistakes, things that were just wrong and cannot be explained by any strategy. The court's going to hear from an expert, Sean Castle, who's going to explain that the family's Google search history and electronic data from their home is exactly what it appears to be. Google searches from a family, from teens, from preteens that are using Google to search for things, sometimes random things, as we would all expect teens to do. And the court is also going to hear from depositions, from documentary evidence that makes clear that anything that anyone testified to about at trial about Todd is going to be a product of them being told that their friend was murdered. And believing their friend to be murdered made statements that were hearsay, that were innuendo, that don't aid in understanding what happened to Ms. Mullis at all. I want to say one final thing about the evidence that the court is going to hear during this trial. Mr. Mullis is here today because the state made the Mullis's private family tragedy public. And I say this because Mr. Mullis is here, his children are here, members of his family are here, and certainly for Todd and his family, they would have preferred that the investigation into Ms. Mullis's case was private, and that their family's privacy was respected, and Ms. Mullis's privacy was respected. If that had happened, and the authorities had made the right decisions in their investigation, then he would not have needed a public hearing like the one today to get the justice that he would deserve. And it is truly unfair to Mr. Mullis, to his children who are sitting here today in support of Todd and his innocence, to have this be the forum to discuss the issues in this case. And I say that because the court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Ms. Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Ms. Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history, those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week. And present them in a public way that Ms. Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved. But that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice. And that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us, and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Thank you, Ms. Thompson. Counsel for the state, did you have an opening you wish to present?
Briefly, Your Honor. Thank you.
Whenever you're ready, Mr. Duden.
Thank you. Good morning. My name is Josh Duden, along with Thomas Bakke and Scott Brown. I represent the state of Iowa in this post-conviction relief proceeding. As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding, which Mr. Mullis has brought and commenced to attack his conviction again. The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis' murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach or a shot in the dark, in a way, is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial and what has already been upheld on appeal. And that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already and find that his conviction of first-degree murder should stand. Thank you.
Thank you, counsel. Are you ready to call your first witness?
Yes, Your Honor. The applicant would call Carrie Petersbacher. Your Honor, is the court's preference that exhibits be put on the screen for everybody and the witness to see?
We can do it that way if you have them on your computer.
We do.
Okay.
I feel like you also have to allow or hit up special buttons.
I do. Let's see if we can get that rolling. Go ahead and have a seat.
I know this is gonna sound so bad, you guys, but like, remember one of the Google searches was like, "Are you raising your sons to be pussies or whatever?" Oh, it sounds so terrible.
Ms. Petersbacher, do you want to pull that screen up in front of you just a little bit? Because that's where the exhibits will display for you.
Okay, thank you.
Okay. Can you see the attorney? Yeah, okay. And you can adjust that so that it's not blocking you entirely.
Okay, thank you.
All right, and I'll swear you in. All right, you've been called as a witness. If you raise your hand, you've been called as a witness. You swear the testimony you're about to give will be true and correct.
Yes.
All right, Ms. Nichols-Cook, whenever you're ready, and just for your benefit, when you identify an exhibit, it will be displayed on my screen and the witness's screen initially. Once it's been admitted, then we can put it up on the big screen, assuming I initiate contact with all the right buttons. All right.
Thank you, Your Honor.
Okay, whenever you're ready.
Ms. Petersbacher, could you state your name for the record today and spell it for the court reporter?
Yes, my name is Carrie Petersbacher, K-A-R-I-P-I-E-R-S-C-H-B-A-C-H-E-R.
Thank you. We appreciate you being here today. Can you tell the court how you are employed?
I'm employed by Edgewood-Colesburg School District in Edgewood, Iowa as a music teacher. I'm currently the 512 band director is my current position.
And do you also volunteer in your community?
Yes, I do. I'm a volunteer fireman and EMT in Greeley and an EMT in Edgewood.
And Greeley and Edgewood would both be towns or their own municipalities?
Yes, they are two separate towns here in Delaware County. They're closely located together. And I work in Edgewood, so we kind of run with both services, and both services do work closely together. So a lot of our calls are shared. If one gets called, a lot of times the other one will as well. Not always, but often.
And both Greeley and Edgewood, are they entirely volunteer organizations? And does Greeley run at the EMT level or at a different level?
We run at an EMT level. That means that we're guaranteed to have at least one EMT on the rig when the ambulance leaves and arrives at a patient.
What can an EMT do?
An EMT does basic life-saving support. We can do CPR, we can splint, we can do basic life-saving care. We cannot do anything invasive, such as in IV, and we cannot administer any drugs through IV or through injection. We can give basic drugs such as oxygen, aspirin, Narcan for a suspected drug overdose, and we can give albuterol for a breathing difficulty or an asthma attack.
Okay.
And those are the 4 drugs that we carry in Greeley that we are allowed to give.
What's the next higher level of care?
After EMT, then you would get to the paramedic level, and they can do those extra things. They can start IVs, they can administer drugs, and that would be the next level up. Edgewood runs a paramedic level, and then I believe in Manchester is a paramedic level, and then Colesburg and Earlville, I believe, are provisional Ps, which means that they sometimes have a paramedic on board, sometimes don't, depending on the availability of their paramedic in town.
And would you consider all of these agencies to be emergency responders or first responders?
Yes.
And how long have you been an EMT?
Getting close to 25 years now. I think it was 2000, 2001, around in there is when I took my classes and completed them. I believe I started them in fall of 2000 and completed them in 2001.
And you mentioned that you had to take a class.
Yes.
What are the components of that class?
The class, I don't remember the exact hour amount, but there's so many hours of class time instruction. It lasted 5 or 6 months when I took the class. It began in late September, early October, and ran through March. We met 2 to 3 nights a week for 3 to 4 hours a night. Sorry. Yeah. So we, 2 to 3 nights a week. And then, so that was the classroom portion. And then as we were taking the classes, you had to pass the different units within the class. Once you passed the class, then you had to also do ride time and clinical time, so many hours working at a hospital ER, making patient contacts and practicing your skills there. And then also so many hours ride time, which would be with an ambulance service, again, making patient contacts and practicing in ambulance situations. Then once that was all done, then you were finally qualified to take the state test where you had to pass skills tests. And then if those were passed, then you went on to take the written test. And then if that was passed, you got your license.
Perfect. And then you could start.
And then you can start, yeah.
And do you also like recertify or have continuing education?
Yes, we have to do the certifications just changed recently. Now the current level is it's 20 hours of recertification every 2 years for an EMT, but there are certain categories that have to be met. You have to do certain hours of cardiac, airway, trauma, et cetera. It used to be, it was just a blanket 24 hours of recertification, any topic. Now they have different topic categories that you have to hit in order to recertify.
Great. And for the paramedic services like Manchester, are they also volunteer or are they employed or full-time employees?
Most of the services in Delaware County are volunteer, except Manchester is a paid service. They are run out of the hospital, and that is their job is to be on call in the ER and run with the ambulance.
And so as a volunteer, if you're not on a schedule or you're not being paid for certain hours, how are you notified when your assistance is needed?
We all carry pagers or radios. Greeley actually carries like radios similar to a walkie-talkie. That if it's set on page, you only get notified when your department is paged, or you can possibly open it up if you want to and listen to everything that's going on in the county. And then you would hear when other towns are getting paged as well. But then when that goes off, then we know that we have a call and we respond to the station.
And you also live here in Delaware County?
I do live in Delaware County.
And did you grow up here?
I did grow up in Delaware County as well.
And so are you familiar then with the geographic area and the roads and where different landmarks are?
Yes.
I want to ask you specifically about a call that, and about November 10th, 2018.
Okay.
Judge, can we approach for a quick moment?
We approach for a quick moment. This witness is pretty useless. Basically, she sees no unusual activity in Todd, and she's told not to leave Todd alone with Amy at the hospital before she's even pronounced dead. Well, I think it's to kind of counteract too the fact though that who was it that was like, yeah, Todd was just like excited, but he wasn't like emotional. He wasn't crying. He wasn't really anything. Yes.
I've just been informed that there are individuals observing the trial who are taking photographs with their phones. That is not permissible. Any phone in the courtroom is to be turned off and put away. If photography, videoing, or anything is observed by any non-approved individual, there are obviously members of the media who have been approved, but any other individual who is taking photos or recordings of any sort. If that is observed or it continues, you'll be asked to leave the courtroom. Thank you.
Thank you, Your Honor.
Yep, you may continue, Ms. Nichols-Cook. Ms. Pierschbacher, you're very fast.
Slow down.
And I
apologize.
don't blame you. Nobody wants to be the first witness.
Yeah.
So if you can slow down just a little bit.
I will try.
Okay, thank you. All right.
Ms. Pierschbacher, I believe we were getting ready to start talking about November 10th, 2018.
Yes.
Do you remember that day and what you were doing?
Yes. That morning, my husband and I had gone to Cedar Falls to pick up our 3 kids. They had a sleepover with their grandparents the night before. And then as we were coming back from Cedar Falls and traveling north on Highway 38, just about home, my husband did have his pager open as I.
Did we ever find out who was doing the pictures during the trial? No, but well, yes and no. I was under the impression that it might have been Phil. You might be familiar with Phil. That's who I was. That's who I was under the impression it was. But do I know that for a fact? No. So it's all hearsay.
I said you could just listening to traffic, and we heard a call from Manchester ambulance to the Earlville area for what appeared to be a farming accident at that time.
And so when you say he had his pager open, are you saying that it was open to the entire Delaware County
Yes,
traffic?
we could hear everything coming across. It's called County Fire. It's the channel that all the fire and EMS are paged on. We didn't necessarily hear what all law enforcement was saying or what anyone else in the county. It was the fire and the EMS paging channel is what he had open.
And you were with your husband, Dave?
Yes, Dave, my husband.
Same last name?
Same last name, yes. David Pierschbacher was his name.
Can you tell me a little bit about Dave and why he had a pager?
He was the fire chief in Greeley. He ran basically the fire side of our service. And at the time I was the EMS officers, which put me in charge of the EMS side of our service, but it was basically one combined service. So yes, we were both members of Greeley Fire and Ambulance. We both carry pagers. His happened to be open to the Delaware County channel at that point in time. Mine was closed to just page.
And do EMTs normally work together in twos or in pairs?
Our protocols is that you always go with at least 2. You never leave the station without 2. And since we are an EMT service, one of those 2 must be an EMT. We do have members of our service who are fire only. We have some people who are EMRs, which means emergency medical responders, which would be the next level below an EMT. There's a couple of skills that EMTs do that EMRs cannot. And we have a few of those. But our protocols are if the ambulance goes, there's a minimum of 2 people on board, and one of those 2 must be an EMT.
And was Dave an EMT?
He was as well, yes.
And it's my understanding he's unable to be here today.
No, he is not here today.
And why is that?
He passed away in 2022.
Okay. So while you were driving back from Cedar Falls, I think you started to say you were listening to traffic and you heard a call. Can you tell us about that call?
We heard, it sounded like Manchester ambulance getting paged for what at that time appeared to be a farming accident. It said that there was a male subject who was transporting a female subject to the hospital along 170th Street, that she had been hit by forks, and that Manchester was paged out to intercept with them. But also at some point it was said that the original location was somewhere near Earlville, because I remember Dave asked me, why is Manchester responding to Earlville? And I said, I don't know.
Was that unusual?
Not kind of. Usually Earlville would have taken that area, but we didn't know, were they out on another call or something else? There are circumstances where different ambulances cover different territories.
And is Earlville also a volunteer?
They're also volunteer.
Okay. And did you have any impression or recollection of what the demeanor was while you were listening to this radio traffic from dispatch?
I just remember everything just seemed very confusing. We were just listening to the traffic, and we heard Manchester ambulance go en route, and we heard them continue to ask dispatch for a location, and that they said that they were coming in on 170th Street. And then at some point we heard them say that the subject had stopped so that they could start CPR on the female victim, but they were somewhere along the road on 170th Street. So Manchester ambulance headed in that direction. And so we were still continuing north on Highway 38 from Delaware to Greeley. And At some point, Manchester Ambulance was continuing to ask for more directions or how far out are they, and they really weren't getting any information. And then Manchester Ambulance asked dispatch to page first responders. And that's when Dave and I said, oh, that's us. We need to get to the station, because we even flipped on our blue light, our light that we use to respond to situations. And we started heading right for the station, thinking that it was us getting paged and we had to get there. And then dispatch actually paged Manchester first responders. So we're like, oh, but we were already at the station at that point. So we just waited for a minute to see what would happen.
And for those of us that didn't grow up in Delaware County, how close is Manchester and Greeley, or along 170th Street?
Along 170th Street. 170th Street, it's also known as the Oneida Blacktop. It is a long road. I don't know, probably 12 miles, I'd say, between Greeley and Manchester-ish. I know it's 17 to my house, but I live a little bit further than Greeley. So,
at some point, while you and Dave were at the Greeley station, did you prepare to respond or leave the station?
At some point, when we continued to hear the voice traffic back and forth of where they located, how far out, Dave did get on the radio and asked Manchester Ambulance if he would like Greeley to respond from that side of 170th to see if we could find them. And figuring between Manchester and us coming from the two directions, eventually we would run into them at some point. And Manchester Ambulance responded yes. So Dave and I got in the ambulance and took off, and we radioed to Manchester that we were en route. We radioed to Manchester dispatch that we were en route.
Okay. And so is it a fair characterization that the people needing help were somewhere on 170th Street? The Manchester Ambulance left from the hospital in Manchester, and then you left from Greeley. And you guys, did you eventually meet?
At some point, we were going to meet up. We actually found the victim first. They ended up being very close to Greeley. Actually, they had not gotten as close to Manchester as we had thought they had maybe gotten. We actually found them just south of Greeley, 2.5 miles, at kind of the intersection of 38 and 170th.
Great. What did you see when you got to that intersection?
When we got to the intersection, the first thing we noticed is the flashing lights from the deputies' cars. At that point, the deputies had arrived. We had just passed that location a few minutes before, but didn't notice anything. Now we saw the flashing lights, and so we're like, that's where it is. And we radioed to Manchester where we were. We went to turn into the driveway, and one deputy ran to the road to meet us to make sure that we saw them and that we knew that's where we were going. So we pulled into the driveway. It was the driveway of a home that was under construction at the time. So there was nobody who lived there. And the driveway was very rocky and muddy. It was under construction. And so when we pulled in, we could see a deputy was performing chest compressions on the female victim, and there was a forklift nearby for the construction of the home. And so after being paged that we had heard somebody hit by forks, I was still thinking bale spears from a tractor. And then I started to think, oh, that forklift was somehow involved in this incident. And so Dave and I pulled the ambulance over as we pulled into the driveway to the left to get out of the way for the other approaching ambulances. I went directly to the victim to relieve the deputy who was giving compressions, and Dave got the equipment out of the ambulance, the Lucas device and the AED.
Okay.
And then he met me at the victim a few seconds later.
And if I missed this, did you know who was building that house or whose property you were on?
I did know whose property we were on. It's the property of Brian and Rachel Krogman.
Okay. And you mentioned that from the radio traffic and from the dispatch statements that you thought you were going to a tractor baling fork accident.
That's what I thought.
For those of us that aren't farmers, a baling fork, a larger item?
It's a large attachment that goes on the front of a tractor to move large round bales.
Okay. And did you have any concerns about a patient being transported by their family towards the hospital?
No.
And why is that?
Because it's common in our area. We're very rural. We all know what the transport times are and what the response times are. I know just for our own department, our goal is from the time of the page to be at the patient within 10 minutes. And I think the community knows that too. So, and I know a lot of people kind of think, well, I can be at the hospital in 10 minutes. And so, no, it is not unusual for a family member to just take a loved one on their own, thinking that they could probably get there faster than waiting.
And in your 25 years of being an EMT, have you responded to other farming type of accidents?
Yes. It's not uncommon in the area. It happens. It's a farming community.
Okay. Circling back to what you saw when you were in the driveway, can you describe the patient and what you did next?
As I approached the patient was lying on her back. One of the deputies was doing chest compressions. I observed she was wearing, it appeared to be heavy chore type clothes, like a thick Carhartt coat. Underneath was a thick hooded sweatshirt. I believe I said she was lying on her back on the gravel driveway. Her head was turned slightly to the right, and her face, the right side, was covered with blood and a brown substance that appeared to be vomit. And the vomit was coming from her nose and her mouth. It was on the right side of her face, and it was also caked in her hair.
Okay. And what was the first thing you did when you reached the patient?
I took over compressions for the deputy.
Why did you do that first?
Because 2 minutes is about the limit that anyone can do good chest compressions. It's just standard that you try to relieve a compressor within 2 minutes if possible, just because after that fatigue starts to set in and then the compressions aren't always as effective. I had no idea how long he had been doing compressions. I was guessing probably longer than 2 minutes at that point. So I was trying to relieve him and get a fresh person on her until we could get the other equipment in place.
And when you started chest compressions, were you doing them over the sweatshirt or over the coat?
The coat was open, but I continued to do compressions over the sweatshirt.
Okay. And did you observe any other obvious injuries or wounds?
No, not at that time.
And were you expecting to see something else?
Well, I was picturing getting hit by bale forks. I was expecting to see very large wounds somewhere and that I was not seeing. And so I was confused as to how the bale forks came into this picture, because I wasn't seeing the massive trauma that I was expecting to see that I would expect bale forks to cause.
And did you know who the deputies were at the scene?
One was Deputy Thompson and one was Deputy Holub.
Okay. Did you guys have a conversation or exchange information about what happened?
We just started talking. I do know at one point when I started compressions and I asked what happened, one of the deputies told me, I think we were dealing with a fall. And then I'm pretty sure at one point I asked, did this happen here? Because I was still under the impression that that forklift I saw sitting off to the side had somehow been involved in this incident. And then that's when Todd, who was in the background, he said, no, this didn't happen here. This happened at our farm a few miles east of here.
Did you know the identity of your patient at the time?
At that point, no, I did not.
Did anybody else from the Greeley EMT team respond?
Eventually, there was a third Greeley person who got to the scene of the patient, Steve Engelken. As I took over compressions, I did ask the deputy to page Greeley for more help, because at that point, our pagers had not tripped yet. It was just Dave and I. I knew we had other people close by that we could probably get there faster, even the Manchester ambulance could, if they would just be paged. And the deputy asked for Greeley to be paged, and the dispatch replied with, Greeley's already on scene, they don't need to be paged. And so we asked again to have them paged for more help. And then Greeley was paged. By the time most of the responders responded, Manchester had already gotten there. So Steve Engelken is another member of our service who did get to the patient. I believe he got there at roughly the same time that Manchester ambulance arrived.
Okay.
But I know he was helping with resuscitation efforts at some point. The rest of the Greeley people arrived, but already saw Manchester ambulance and Greeley ambulance and everyone there. So they stayed on the road and conducted traffic control and did not approach the scene.
Okay. And then you mentioned that Dave got the Lucas device and the AED off the ambulance. Can you tell us a little bit about what a Lucas device is?
A Lucas device is basically an automatic CPR device. There's a board that resembles, I don't know, maybe a snowboard would be the closest comparison I can think of. Has a slight curve to it. It goes under the patient's back, like from armpit to armpit. And then there's another U-shaped device that comes down and clips over top of that. And then from that device, there's a plunger that goes down onto the patient's chest. And then once it's turned on, the plunger does the compressions for you. So then the manual compressions are no longer an issue and we don't have to worry about rescue or fatigue. The Lucas just keeps going with good quality compressions.
Okay. And so, and then how is an AED different?
The AED is an automatic external defibrillator. That is the part that actually attaches to the person's chest and shocks the heart to try to get it back into rhythm.
Okay. And what did you do? What did you guys do first?
Once Dave got to us with both of those devices, the first thing we did is attach the AED. At that point, we pulled the victim's sweatshirt up and we attached the two pads. The pads go upper right, lower, and then on the right side, and then on the rib, lower rib on the left side. So we attached the pads, we turned it on, it analyzed, and then an AED is looking for a certain cardiac rhythm before it will issue a shock. So as it analyzed, we stopped our compressions and let it analyze, which is protocol. And then the first time it analyzed, it said no shock advised, which meant it did not pick up that shockable rhythm. So continue CPR, so we continued CPR.
Okay. And when you pushed your patient's clothing up, did you make any observations about other injuries?
Yeah, we looked, as we lifted up her shirt, we were looking for some other things to see, because I was still trying to figure out how this injury happened. There was what appeared to be possibly a slight bruise on the right rib cage. At that point, it was very faint. We thought maybe it was a bruise, but we weren't 100% sure. And then there was also a mark above her right breast that looked possibly like a very small puncture wound. But again, we weren't 100% sure what we were looking at. We saw something there, but
We saw something, but were not able to determine what had caused that. So we made note of it in our report.
Did you observe anything, any injuries on her face area?
Again, possibly a slight bruise on the right side that was noted in the report. Again, at the time that we saw her, it appeared very faint. We thought it was possibly a bruise, but we were not 100% sure. So again, we noted it in the report.
Okay. After you set up the AED, did you then do the Lucas device?
Yes, once we did the first analyzing with the AED and said, no shock advised, continue CPR. I continued manual chest compressions, and then Dave and the deputy started setting up the Lucas device. Dave started and the deputy assisted with getting everything in place. I continued manual compressions until the Lucas was in place and could start.
Okay. And you were able to utilize the Lucas to do chest compressions?
Yes. And then once it was in place, we turned it on and the Lucas took over chest compressions.
What did you do after that?
Then I went back to the ambulance to get the airway bag to secure an airway and to start breathing for the patient. So I brought the airway bag back to the patient, opened it up. I took out a King LT. That was the intubation device preferred at the time. And so that's what I took out. At the time that I had gotten that out, then that's when Manchester arrived on scene.
Okay.
I apologize for the interruption, but we have a quick sidebar.
Sure.
Yeah, so far, not the most exciting witness. But I think just to kind of show what was happening at the scene, kind of set the scene maybe, and just show that they were the ones working on Amy.
Posts, the individual will be removed.
Back to the phone.
As was proceeding,
Person taking
I hope we have no further interruption. I think you just get faster and faster. Okay. All right. Ms. Nichols-Cook, whenever you're ready.
Thank you, Your Honor. Ms. Pierce-Parker, maybe act like we're high schoolers, I guess, and we don't listen the first time and just go slow for us. But we were talking about an airway bag, and could you help us all understand a little bit about what you were using? I think we've all seen mouth to mouth. And so tell me about the airway bag.
Okay, so our airway bag specifically carries all of the equipment that we would need if a patient were to have a breathing problem. There is an oxygen tank in that airway bag. There is also it's called an AMVU bag. It's the bag that you put over their mouth and squeeze to help ventilate them. That we carry in there. There is also nasopharyngeal airways, which go into the patient's nose, and oral airways, which are hard airways that go into the patient's mouth that are used to hold the tongue out of the way. Those airways are used for a patient who is still semi-conscious and would have a gag reflex, who would not tolerate anything down their throat. In this particular case, we used a King LT, which is a long tube that is inserted into the patient's mouth, and it goes into their trachea, and there are two balloons that blow up to hold it into place. And then there's a small opening at the top that AMVU bag I was talking about. If you take the mouthpiece off, the round tip goes right onto the top of the King airway, and then we can ventilate directly into the patient's lungs. So that is what I was getting, the airway bag, and that's what we had decided was our best option for that patient at that time.
Okay. And was your patient responsive at all?
No.
And in order to insert the tube then into your patient, did you have to do anything with her mouth or her nose?
Yes. So when I inserted the tube, what I did is I positioned myself at her head so that she was directly in front of me. I was at the top of her head. Other people were still working on doing things with her. I was kneeling on the ground above her head. And then what I do to insert is I reach through and I grab her lower jaw and her tongue, and I lift it up to pull the tongue out of the way and to open her mouth. And then with my other hand, I take the tube and insert it into her airway. And then we have a syringe that then blows up those balloons to hold that tube into place.
Okay. Earlier, you mentioned that the right side of your patient's face had blood or maybe a vomit substance.
Yes.
Was that still present when you were inserting the tube?
It was still present. And before the tube was inserted, we used a suction device to suction her mouth clean and clear so that we could get the tube in without getting any extra debris into her airway.
Would getting debris in her airway be harmful to your efforts to get her breathing?
Well, it could, because then it would be basically like aspirating whatever that was, and then it would just cause further problems for the patient down the road.
And I think you mentioned that as you were working to do this, the Manchester paramedics arrived.
Yes, the Manchester crew arrived because at first when they arrived, we filled them in on the situation and told them what we had done so far and what we knew. And then I actually backed off on the airway for a moment, just because at that time it was their scene to control. And I just said, we're about to insert an airway. And then that's when they said, well, you are an EMT, you can do that skill, right? And I said, yes, I can. And then they said, please do help us. And so we stayed on scene and continued to help them as they were doing what they were doing.
And in addition to suctioning out the mouth and the nose, did you also have to move her face or handle or wipe things off of her?
I don't remember if we did any wiping. I do know we did have to suction, and then her head was turned slightly to the right, so we would have pulled her head back to center to make it easier to insert that tube.
Okay. After you inserted the airway tube, what do you remember doing next?
At that point, then we hooked up the airway bag, and I started to ventilate for her. The ventilations were going in harder than I expected them to. I was feeling some resistance, which is not normal. But at that time, that's when we were getting ready to move the patient. They had brought a sheet from one of the ambulances. And so the way that we lifted her that day is we did something called a log roll, where we roll the patient onto her side, put the sheet under her, pull it back out from the other side. And now she's laying on a sheet instead of on the bare ground. And then we're able to use that sheet to lift her and get her onto the cot and into the ambulance. So the sheet was the method that we used that day to get her up onto the cot and loaded. So at the time I got the airway in place was the time that we rolled her, got her onto the sheet, and moved her towards the ambulance. I was ventilating the whole way to the ambulance. When we got to the ambulance, I did tell the paramedic, please check this airway. There's more resistance than there should be. Make sure I got it right. And then I handed the airway bag off to one of the Manchester personnel, and they continued care to Manchester.
Did you note any other injuries during that log roll procedure?
During the log roll procedure, I did not see any other injuries myself. As the patient was rolled, I moved with her face to continue to give ventilations. I did hear one of the Manchester responders say, we have a through and through, when they saw her back. I personally never saw her back at the scene. I don't know what it looked like, but I did hear one of the Manchester responders make that comment.
Did you note any other injuries to her mouth, a cut, or anything like that?
No.
And in your experience, is the act of performing CPR or using a Lucas device a traumatic event to the body?
It can be, yes.
Was your care ending then as the patient was loaded into Manchester's ambulance?
Yes, that is where our care of the patient ended. We handed off to Manchester. Shortly after Manchester ambulance arrived on scene, so did Manchester first responders, because they were paged out after. So between those two crews, they got enough people in the back of the ambulance to continue care all the way to Manchester. So it was Manchester's full ambulance crew. And then I believe a couple of their first responders who came out in the first responder rig also went back with them to be extra hands to help with resuscitation. So we were not needed to go in the ambulance with them. They had enough people.
Okay. And at some point, do you learn the patient's name?
Yes, as we were loading her into the ambulance, one of the Manchester responders or ambulance members said, we need a name and a birth date for the victim. And then that's when we asked, what is her name and birth date? And that's when we learned it was Amy Mullis. Up until that point, I didn't realize who we were working on.
Had you met Amy Mullis before November 10th, 2018?
Yeah, we were acquaintances. Amy's and Todd's daughter was in gymnastics with my daughter, so we would see each other at gymnastics events, and they also attended the same church as us.
Did you realize the individual providing information to you during your care was Todd Mullis?
I did not realize that either at the time. It was out of context. I was used to seeing him together with the family, and this was out of context. So no, I did not place that. That was Todd as well.
Can you describe Todd's demeanor while you were on the scene?
From what I observed, he seemed to be kind of anxious, nervous. He seemed to be pacing in the background. He wasn't interfering with resuscitation efforts at all, but he was close by to provide information as we would need it. As if we would start to talk about something or ask something, he would respond right away with information he had or knew. But yeah, he was close by enough to give information, was pacing.
Nothing that alarmed you?
No.
I'm sorry, start over. Did you also then know Todd and Amy's children?
I did. At that point in time, I knew the younger two children better. Wyatt and Taylor went to church with us. I was their Sunday school teacher for a while. I knew Tristan also at that point from seeing him in church with the family, but I did not know him as well as I knew the younger two.
Did you see Tristan on November 10th, 2018?
Yes, a little bit later. Up until that point, I had not noticed him. After Amy was loaded into the ambulance and Manchester took off for the hospital, we turned to start getting our stuff picked up, and that's when I realized Tristan was there as well. He was standing back a lot further than Todd. There was a trailer attached to the pickup that they had been using to try to get Amy to the hospital, and he was on the back side of the trailer.
Okay. After the Manchester ambulance left, what did you and the other Greeley EMTs do?
Because some of the Manchester first responders had left in the ambulance service, or in the Manchester ambulance, that left a couple of their first responder vehicles unmanned. So our other responder, Steve, who was on scene, he actually helped Manchester to get the rest of their vehicles back to their station. Dave and I took the ambulance and we followed to Manchester because our Lucas device was still being used in resuscitation efforts. And so we said we would just follow and wait for it to be done to get it back. So we proceeded to Manchester. We stopped at the fire station we stopped at Manchester Fire Station to pick our other responder, Steve, up, because that's where they keep their first responder vehicles after he helped them drop those off. And then the three of us proceeded to the hospital to wait for the Lucas.
Okay. When you got to the hospital, where did you go?
We just went into the common area in the ER, the hallways. We were just planning to hang out in a corner and try to stay out of the way until things were done.
And did you observe Todd Mullis or any of the other family there as well?
Todd, I believe, was there and had a friend with him. And they were in kind of the family waiting room. They had a special waiting room, not the general public waiting room that everyone goes into. There's a separate one back in the ER for family to wait in. And so he was in there with a friend.
Okay. Did medical staff approach you and Dave or Steve?
One of the RNs came up to us as soon as we got there and
what did you and Dave do after you interacted with medical staff?
We waited. Dave we would take turns waiting in the family room with Todd. Dave spent most of the time in there. I went in, I believe, once for a couple of minutes.
And were you asked to go in? Were you instructed or informed that you needed to go into the waiting room?
Objection, calls for hearsay, relies on hearsay testimony.
Your Honor, it's been offered to show what she did and why she did it.
Overruled. The witness can answer.
We were told to make sure Todd was not left alone and to make sure one of us was with him at all times.
Hearsay again, ask that the objection precede the response, Your Honor.
Overruled. The answer will remain in the record.
In your 20 plus years of experience as an EMT, has that ever happened to you before?
No.
Did you make any observations of Todd's demeanor while you were in the waiting room or at the hospital?
It was similar to on scene. He appeared anxious to me, was pacing.
At some point, were you able to not stay in the family waiting room any longer?
Another RN came in.
Are you familiar with former Sheriff LeClaire?
I am.
Did you see him at the hospital on November 10th?
I did.
Did you speak with him or see him speak to anybody?
I did not.
Calls for hearsay response again, Your Honor.
I didn't ask what was said, Your Honor.
I did not speak to him myself. I did observe he and Dave speaking to each other.
And since Dave was a fire chief in the county, was that unusual or alarming?
No.
Okay. At some point, were you able to retrieve your equipment and depart Manchester Hospital?
Yes. At some point when the Lucas device was finished being used, we got it back and then we left and returned to Greeley's fire station.
Okay. Did you respond to any other EMS calls that day?
We did have another EMS call later that night.
Medical center in Manchester?
Yes, we transported that patient there as well.
Did you ever learn that there was concerns or instructions to complete your report in a certain way?
When we returned back for that second EMS call that night, we were actually with Edgewood crew at that time. Edgewood was the transporting service. They needed extra help. So Dave and I both ended up being in the back with the patient on the way in. When we got to the hospital, I stayed in the rig and started cleaning everything up. Dave and the rest of the Edgewood crew members actually delivered the patient into the ER. When Dave returned to the ambulance after dropping the patient off, he told me that—
Objection, Your Honor, hearsay within hearsay.
Sustained.
Let me try to rephrase a little bit there. Did you complete a report about the service call regarding Amy Mullis?
I did.
And did your husband, Dave Piercebacher, contribute to that report?
He did.
Did your colleague, Steve Ingleton, also contribute?
He did.
Okay. And did you have an understanding that you need to take some extra care or caution when writing your report?
Yeah, most reports are completed thoroughly, though. I usually I always make a point that every report is completed thoroughly.
And at some point, did you learn that Amy's death was being investigated as a murder?
I did.
And do you recall when you learned that?
That evening at the ER.
I've got a copy of your report here marked as Exhibit 216. If we can show that to you to make sure we have the right report. We'll try to get it on the screen there for you. Mr. Clark, have you had an opportunity to look at Exhibit 216?
Yes.
Okay. And does this appear to be the report that you wrote and submitted
It appears
regarding?
to be.
Yeah, I didn't know
And
that.
can you tell,
The biomed engineer died? Damn.
the date that you submitted this report?
I'm not sure it's on this front page, but if I remember correctly, it was November 13th.
And so that would have been just a couple of days after
Yes.
you responded to the call? And I think you just said you submitted it. Can you tell us a little bit about what that means? Like, how do you submit it? Where does it go?
The system that we use for EMS reporting is called Image Trend. We all go in and it's what every EMS service uses. We complete the report and then it stays open. And when we are satisfied that it is done, we hit lock and submit, and it is locked and submitted, and then it uploads to the state database. And at that point, then it is considered submitted.
Okay. And after you submitted your report here in Exhibit 216, did law enforcement ever talk to you about your observations from November 10th or your report?
No.
Did anybody from the...
So Spooky's both sides have to have their briefs into her by April 8th, and then she'll make a decision. Paul was saying the other night that he thinks that she actually has a couple months to make the decision. I was going to look up if there's like a physical deadline, but I mean, she has from now until then to review everything, and I wouldn't really be surprised if she already kind of has a decision. It's just like the final things that have to be put in for legal purposes. So I wouldn't be surprised if we hear something pretty shortly after April 8th, but she does have some time. I just don't know the exact amount of time. So sometime in April, we'll hear her decision. Paul, do we know what that conversation was? That is that the one that she was kind of trying to talk about, and they were like, no, don't do it? The state was like, nope, hearsay.
The Delaware County Attorney's Office talked to you about it?
No.
And I apologize.
Well, it kind of sucks because Dave's dead. So, I mean, all there is left now is hearsay.
I said law enforcement earlier, specifically Delaware County Sheriff. Did anyone talk to you? The Iowa DCI?
No.
Okay. And have you ever spoken to anybody from the Iowa Attorney General's office about the substance of your report?
No.
Okay. And were you aware, or are you aware now, that Todd Mullis was charged with Amy's murder and tried and convicted of that?
Yes, I am aware of that.
And then we'll flip to Exhibit 215 and have you identify that for us.
Yeah, this is an affidavit.
So 215 is an affidavit that you signed regarding November 10th.
Yes.
And my copy's a little faint, so maybe yours is a little better, but is it dated in 2023?
I believe so. I don't see the signature page on my screen, but I believe that's when it was.
We'll scroll for you.
Yes, 2023.
And prior to this affidavit in 2023, did you speak with any attorney representing Mr. Mullis?
No,
Any private investigators or anybody talk to you?
no,
Was there anything about Todd's behavior or demeanor on November 10th that was alarming to you or caused you concern?
no.
Your Honor, if I could have one moment, and then I think we already have an agreement to admit 215 and 216, but I would formally move to admit those exhibits. You just got one or two more. I apologize. Thank you for your patience. Ms. Piersbacher, while you were on the scene that day providing care and waiting at the hospital, did you ever observe any or hear anything that caused you to think that Ms. Mullis's injuries were not an accident?
No.
And I know you said earlier that it's not uncommon for there to be farming accidents. And so can you expand a little bit on that? Like what types of accidents you have responded to over the years?
Your Honor, I am going to object on the grounds of beyond the scope of the lay witness's testimony. She's not a certified expert, and it's her testimony as to other incidents are relevant for her insight and for purposes of this proceeding.
Sustained.
Let me re-ask that. Have you responded personally as an EMT to other farming accidents?
Yes.
And have those included things like falls
Yes.
and onto whether it's a farm implement or a fork or some other tool?
Objection, Your Honor. Again, this is irrelevant. It's both beyond scope, not an expert, and simultaneously leading.
Your Honor, I'm asking for her personal experience. I'm not asking for an expert opinion.
Yes, we have been called to emergencies that involve farm implement, and we have been called to emergencies where people have fallen. We've been called to emergencies where people have been trapped. Yeah, there's several different types of farming emergencies that happen.
Okay. One last question is, do you have any recollection of the weather on November 10th? It's winter in Iowa, but other than that, do you have anything?
It was very cold. I remember it was very cold, very bitter. I believe there was like a skip of snow on the ground at the time.
Okay. Nothing further from you, Your Honor.
Counsel, any objection to exhibits 216 and 215?
Your Honor, no objection to the inclusion of 216, but we would object to the inclusion of Exhibit 215. As it is hearsay, includes hearsay within hearsay as well, and is inadmissible. I believe it also predates the filing of this case and therefore was not made as part of the record for any sort of consistency.
216 is admitted. Counsel, did you want to respond to the objections 215?
Yes, Your Honor. I think there might be some confusion. I guess it was my impression the state had already didn't have any objections to 215, but additionally, it's a part of the original post-conviction relief application filing in this matter. Ms. Piersbacher has identified it, and I can ask her some additional questions as far as, where the information comes from in it. But I do believe it's an admissible document that this court should consider.
Well, to the extent it was identified as an attachment, I guess, to the petition, it's there. The court will consider it in that fashion. Generally, I'm not going to admit affidavits, though, of witnesses who are here to testify. So 215 is not going to be admitted as a separate exhibit. Cross-examination.
Yes, Your Honor. Good morning, Ms. Kirschbacher.
Good morning.
At the time of Ms. Mullis's death, you had been an EMT or volunteer firefighter for about 20 years. Is that fair to say?
Just shy of that, yes.
And since then, obviously, you are still a volunteer.
Correct.
On the day in question, you were dispatched around 11 minutes after noon, right?
Yes.
And you arrived somewhere around 12:14, 3 minutes later.
Yes.
According to your report, which has now been admitted as Exhibit 216, you reached Miss Mullis or Amy Mullis for an assessment at 12:15, right?
I believe if that's what it says in the report, then yes.
And the Lucas device that you explained earlier was placed a minute later.
Yes, if that's what it says.
And at that time, you left Miss Mullis's body, ceased compressions, and went back to the ambulance, right?
I did because compressions were being taken over by the Lucas device.
So you didn't visualize her during that period of time.
I did not.
And you didn't administer the AED shock at 12:17 either, did you?
Whoever was running the AED did at that point. That's the time that it was shocked.
And I believe if we turn to directing your attention to what is page 4 of Exhibit 216, I believe it references that David Pierschbacher was the one who placed that AED shock, right?
That is possible. Yeah, I don't have that page in front of me, but if that's what it says, then that's what happened.
And 1 minute later, Manchester Ambulance took over the care of and administered the life-saving efforts for Miss Mullis, right?
Yes, once they arrived. Yes.
So the entirety of your interaction spanned about 3 minutes.
Probably, yes.
And for the portion of those 3 minutes, you weren't actually with Miss Mullis the whole time, were you?
Not the entire time, no.
And according to your report, as has already been admitted, you didn't see the injuries in question, right?
I did not.
And you didn't observe the full extent of any puncture wounds, right?
I did not.
You don't document any direct references to Todd Mullis in your report, do you?
No.
You never once reference Tristan Mullis in your report, right?
Correct.
And you were familiar with them, as you mentioned, right? Because your focus was actually on Amy Mullis and preventing her or administering life-saving care.
Correct.
Right? So what we do know from your report is that you'd agree that she had bruising documented to her face.
Yes.
And you didn't actually note anything about her hands in question, correct?
No.
In fact, based upon your examination, you had no reason to check her hands, fair?
We did not.
So you can't say whether or not she had any injuries to her hands, right?
That is correct.
Nor could you say that she has any injuries to her legs or feet, right?
No. Those, that was removed by Manchester Ambulance. They cut the rest of her clothing off of her when they took over care. So that's why that is not in my report, because that was under their care.
So directing to your specific interactions with Amy Mullis on this day, you administered manual compressions.
I did.
And you placed the King airway device, right?
I did.
Tube. How long or how many tubes have you placed, would you say?
Over the years.
Did we get a little, I'm sorry, objection, a little foundation as to like a time period? Are you talking the entire 20 years or?
Sure. In a general sense, without holding you to any specific number, over your 20 years time at that point, how many airway devices had you placed? How many tubes?
At that point, well, those were relatively new at the time. I mean, we haven't had those in the entire 20 years that I had been an EMT, but I have placed a dozen.
So you were fairly experienced or aware of how to place them?
Yes.
And to be fair, those don't come into contact with a patient's lips or anything like that specifically, right?
No, mostly it's my hand that comes in contact with her face or her lips as I'm moving her face out of the way to put the tube in.
And in this instance, Manchester Ambulance is the one who was doing the suctioning, not you,
yes,
right?
Yes, that is correct.
So you weren't applying any force with an outside suction, right?
No.
And do you recall or have any reason to believe you caused an injury to her lips yourself?
No.
And generally, when you place a King airway tube specifically, do you cause injuries to the patients you place them or administer them to?
I have not heard of that.
And in your instance, that hasn't happened, right?
No, not that I'm aware of.
So you don't have any reason to believe that you would have caused any damage to Amy Mullis's face or mouth or otherwise, right?
No.
And you didn't ride with her to the hospital either, did you?
I did not.
So your care or interactions with Amy Mullis ended at 12:18 or so.
Yes. Whatever time she was loaded in the ambulance, that's when my interaction with her stopped.
And so your total interaction with Amy Mullis would have been 3 minutes, right?
Probably, yes.
In your report, you don't call it a farming accident, though, do you?
What did I reference it as? What did I put in my narrative?
I believe when you were dispatched, and you can correct me if I'm wrong, that, like you said earlier, you believe that a woman had been hit by forks, right?
Yes, that's what it was dispatched as.
You don't mention a forklift, though, do you?
No.
And you don't mention any bale spears, right?
Nope.
So overall, you had no reason to believe or any reason to look into the cause of Miss Mullis's injuries, did you?
Just to ask what had happened, and again was told we weren't sure. We thought we were maybe dealing with a fall, was the answer that we got on scene.
Is it safe to say that the family members who are noted in your report, that would be Todd Mullis?
Yes. I believe I just referenced family members in general, correct?
Correct.
Yeah.
So in that sense, it would have been reported as an unknown incident to you, right?
Yes.
So it wasn't referenced as an accident by Mr. Mullis. Fair?
No,
I'm going to object at that point as asked and answered and beyond this witness's testimony.
Overruled, the answer will remain in the record.
That was you? Yes?
sorry, could you please re-ask that question?
So Mr. Mullis had never referred to it as an accident or otherwise to you, right?
No, it was very confusing. We were trying to figure out what had happened. As you said, the 3 minutes that I was with her, we were trying to see if we could resuscitate her. So that was our primary cause. In my mind, I was running over what could have happened, but our primary focus was to get her back, get a heartbeat and breathing.
So your job wasn't to look into what caused the
No.
incident in question?
We asked the questions to help us figure out what we're dealing with. But in this case, it was very confusing. Nobody really knew. So we focused just on what we could see and took care of that.
So we've referenced your report extensively, which has now been admitted as Exhibit 216. Who do you submit that report to?
I believe it goes to the Iowa Department of Health.
So it doesn't go to any specific agency for inclusion, right?
No, it gets uploaded to the state.
And I believe you've previously referenced the National Emergency Medical Services Information System.
Mm-hmm.
Fair?
Yes.
Is that also called NMSIS?
Yes.
And for NMSIS, do you know who that goes to?
I do not.
So is it safe to say that you've never in your 25 years checked into where that goes, right?
No. I do know that when our service gets inspected every 3 years by the state, the Iowa Department of Public Health comes out and they do have access to all of those reports, and they have all of our information on when reports were filed and in what a timely manner, and that is checked into them. So I do know that at that point, the Iowa Department of Public Health Emergency Services Agency, who keeps track of the EMS services, they have those reports.
And so those reports don't actually go to anyone other than the state agency designated to receive them, right?
As far as I know.
And in that case, the NMSIS program is actually administered at the federal level. Fair?
I believe so.
So that data is not being aggregated by, say, the hospital in Delaware County.
I don't know.
You have never provided the report specifically to a hospital in Delaware County, right?
Not that final report. No.
Did you provide any other version of a report to a healthcare provider in this case?
Yes.
And so that would be documented in the medical records or referenced otherwise?
It should be in Manchester's report that they received ours. What we usually do is when we get on scene, we don't pull out our computers and do the final report there. We have handwritten notes and we pull off the top sheet and it goes with the patient. So in this case, when we handed off the patient to Manchester, our top sheet of notes went with her, with Manchester, to become part of their report.
And that's because it was Manchester who was in charge of her transport to the hospital?
Because they transported her, yes.
And in charge of handing over care to the hospital emergency room?
Correct.
So that wasn't you in this
We
case.
did not hand her over to the emergency room. No, we did not. We handed her over to Manchester Ambulance Service.
But on scene, you talked to Todd Mullis, correct?
Yes. Well, in passing, he was in the background giving answers. I did not specifically talk to him one-on-one.
You also confirmed some of the details with the deputies, yes?
Yes,
And so in question, you were also known to the Mullis family, weren't you?
I believe so. Somewhat more so Amy and the younger two kids at that point in time.
Because you went to the same church and your family was interactive,
Yeah.
right?
Yes.
So at that point, Todd Mullis and you were already familiar?
In passing, as an acquaintance.
Ultimately, it's safe to say you can't actually explain the full extent of Amy Mullis's injuries that she sustained that day, right?
No, I cannot.
And you can't describe the extent of the location of where her injuries were seen?
No.
And your report would only document the injuries that would already be noted in her medical records or by other care staff, right?
Objection beyond the scope of this witness's knowledge. There's been no foundation laid that she's ever seen medical records from a hospital related to Ms. Mullis.
Kelly, can you read me the question? I'm sorry.
Your report would only document the injuries that would already be noted in the medical records or by other care staff, right?
I'm not sure I understand the question.
I'm
Would you mind
happy to
repeating
rephrase,
one?
Your Honor.
Right, thank you.
You mentioned earlier that the extent of the injuries would have gone to Manchester Ambulance, right?
Correct.
And that Manchester Ambulance would have provided that information also to the hospital, correct?
Yes, they should have. Yes, I assume they did.
And that's because they ultimately transferred care to the emergency room, right?
Correct.
So the bruising on Amy Mullis's face or the puncture wounds to her body or any other documented injuries would primarily be noted by her medical records or by that staff. Is that fair?
Possibly.
Because you would have provided or noted the same injuries that were noted by Manchester Ambulance, right?
No, objection, Your Honor. I think the question is asking this witness to say what Manchester paramedics did or what's in the Manchester reports, which she has not seen or nor did she write. So this is an improper question and ask for speculation.
Sustained.
After you responded for those and provided those 3 minutes or so of care, did you have any other interaction with Amy Mullis?
No,
You did not provide the report to any law enforcement, correct?
no,
And you normally would not provide those reports to law enforcement,
not
right?
unless asked.
I don't have anything further, Your Honor.
Any redirect?
Very briefly, Your Honor. Ms. Pierce-Bacher, law enforcement knew you were on the scene.
Correct,
You've been a member of the Delaware County community your entire life.
correct.
Law enforcement spoke with you while you were providing care.
Yes,
Is it a normal protocol and or is it required by the Department of Public Health that you complete and submit a report?
yes,
Do you have any obligation to send that report out to the law enforcement you interacted with?
no,
And you mentioned that you would have taken the top sheet of your notes and sent them with the patient. When you describe that, are you describing like a carbon copy where you also kept a copy of
Yes.
those notes? And we talked a little bit earlier about you submitted this report, but it included observations and actions of the other two EMTs from Greeley.
yes,
And is that normal protocol for an EMS EMT report?
yes,
And you were asked about your entire interaction with Ms. Mullis only being about 3 minutes. Is that unusual?
no,
You were asked a little bit about the dispatch and the farming records. And I believe you testified, so I just want to clarify that you heard over your pager, over the radio, and dispatch was calling it a tractor, baling, fork type of accident.
yes,
And you and Dave responded from Greeley in part because Manchester was not responding fast enough or could not find the patient. Is that your understanding?
yes. There was confusion on where exactly the patient was located and how long it would take Manchester to reach them.
Ms. Pierce-Bacher, you heard us talk a little bit about your affidavit. Is there anything in your affidavit that you feel is not accurate or reflective of your experience on November 10th?
No,
Objection relevance, Your Honor. This affidavit's already been excluded.
The objection's overruled. The answer will remain in the record.
Did you ever talk to anybody from the state medical examiner's office about Amy Mullis's death?
no,
Nothing further, Your Honor.
Any recross?
None needed, Your Honor.
Thank you. You may step down.
thank you.
Let's go ahead and take a morning recess for about 15 minutes. I'll see you back then.
Prosecutors are just so annoying. But that attorney has like major eye roll syndrome. The prosecutor objects and she's just like, shut it. I think everybody remembers
Ms.
her.
Thompson?
Thank you, Your
Whenever you're ready.
Good morning, Dr. Cruz.
Good morning.
She is bitter. She does not want to be here for this at all.
My name is Sarah Thompson. I'm one of the attorneys for Mullis in this case.
Okay.
Could you please state your full name for the record?
My name is Kelly Cruz. It's KELLYKRUSE.
I may be the only person that's having this problem. I'm eligible here.
Sure. And I can't see.
I'm sorry, there's no light on it, but
You did the, yeah, perfect. Okay. And Ms. Thompson, your microphone's not on either. There we go. That may
Thank
help.
you, Your Honor. All right, with that out of the way, Dr. Cruz, you gave testimony in Todd Mullis's trial, criminal trial back in 2019, correct?
correct.
And at that trial, you testified about the autopsy that you performed on Miss Amy Mullis back in 2018, right?
Correct.
And you prepared a report based on the autopsy that you conducted.
Correct.
In your trial testimony at Todd's criminal trial, you gave your opinions about the cause and the manner of Ms. Mullis's death.
Correct.
And at that proceeding, you testified that the manner of her death was a homicide.
Correct.
And you testified that it was your opinion that someone struck her with a corn rake and that killed her.
I testified that she had injuries that would be consistent with those caused by the corn rake.
Was someone striking her with the corn rake and that causing her death?
Correct.
Those are opinions that you maintain today, Dr. Cruz, is that right?
Correct.
And you're not here at these proceedings to offer different opinions than the opinions that you've already given in your prior report and your prior testimony.
Correct.
You reached your opinions about the cause and the manner of Ms. Mullis's death at the autopsy that you performed on November 12th of 2018. Is that right?
Yes.
And you based your conclusions about the cause and the manner of her death on what you learned at that autopsy, right?
Yes.
Is there any disagreement in your mind or any confusion in your mind that Ms. Mullis was found with something called a corn rake that had been impaled in her back and her side?
That's information that has been consistent, so I don't have any reason to not believe that.
And it's also your understanding that after that occurred, that she was rushed to the hospital, right?
Yes,
And that it was her husband, Todd, and her son, Tristan, who took her to the hospital?
that's what I've been told, yes.
And it's your understanding that they got partway down the road to the hospital when they were met by emergency medical services people who, Mullis?
Yes,
And then it's those EMTs that then took Ms. Mullis to the hospital?
yes.
And she died at the hospital at 1:08 a.m.?
I'd have to check the time.
And sorry, I misspoke. She died at the hospital at 1:08 p.m., correct?
I would still like to check the time, but she died at the hospital.
Well, she died at the hospital.
Correct.
After she passed at the hospital, the medical examiner that was covering Delaware County at that time, Dr. Craig Thompson, he called your office?
Yes.
And he told you that he was sending Ms. Mullis's body to your office for an autopsy?
Judge, I'm going to object. These questions are all leading.
They are.
Oh, she for sure got it.
I appreciate Ms. Thompson moving things along, if that's her intention in using leading questions. But since there's been an objection, if you could rephrase and avoid using leading questions.
Your Honor, this was the subject of the pretrial motion that the applicant filed, and I do want to be heard on this issue. We filed a pretrial motion about this exact issue. We can take it up at sidebar or with the witness, but we filed a motion about this issue.
Okay. Did you want to take it up in a sidebar or just take it up on the record? Obviously, I assume you're referring to the issue of this witness being taken out of order.
I'm not, Your Honor. Yes, and I apologize because I truly thought this issue was resolved.
Okay. I guess I'll leave it up to you if you'd prefer to take it up in a sidebar or just on the record now.
I don't think it impacts the content of the witness's testimony, so I'm fine for the witness to remain.
Okay.
The motion that we filed addressed a couple of issues. One, that this witness is an agent of the state, and as such, under the rules, I'm allowed to cross-examine her because she's not a hostile person with respect to the witness, but
So that the sidebar, so that they don't have to remove the witness. So if whatever the attorneys are going to say, if it's going to impact whatever the witness's testimony is going to be, we kind of talked about this during the trial. This is the big part where Todd's attorneys are arguing that she, the forensic pathologist, is an agent of the state, and the state comes forward and they're like, no, she's fair and down the middle, and she doesn't work for either side. She's just there to give her opinion after her evaluations. And then we come to find out that she refused to even talk to Todd's attorneys or their experts to even get additional information to make a decision, due to the Attorney General's office telling her not to do it. So if she doesn't work for the state, then why in the world is she taking advice from them and not doing things fairly, essentially, to kind of just break it down? So this is going to be the argument. So they're asking her questions that she didn't really want to answer. The state is saying, hey, we're objecting to this because you're going down this path that we don't want you to go down. And now his attorneys are saying, no, she's a state agent and we should be able to ask her these questions.
That she's hostile for purposes of the rules. This witness is an agent of the state, and as such, under the rules, I'm allowed to cross-examine her because she's not a hostile person with respect to the witness, but she's hostile for purposes of the rules. This is also relevant to the burden that Mr. Mullis has to prove at this hearing about what her testimony, what the trial would have been like with additional information, and she would have been a state's witness at trial, and she would have been cross-examined by trial counsel. So a cross-examination is appropriate regardless of who is proffering the witness. We certainly are proffering this witness. But the issue of her being an agent of the state alone
makes it appropriate for me to.
Sidebars are in the transcript. They're just not for, so like the court reporter is tracking everything that's said in a sidebar. And it ends up in a court transcript.
Lead her.
Any response, Mr.
Judge,
Brown?
this is a witness they're calling regardless of what her position was at the previous trial. These are leading questions. Developing an issue and asking leading questions in some respect is fine, but we're going to be getting into other details relating to Dr. Cruz's opinion. They're calling her as a witness. I think they should be made to follow the rules of evidence, so that's why we're objecting.
Yeah, this is a different situation. I don't think there's been an issue of establishing Dr. Cruz as a hostile witness in any sense. As far as her being an agent of the state, counsel, if you want to lay some foundation to establish, again, that agency relationship, something that would support or demonstrate a rationale for treating her as a hostile witness, you may do so. But for now, let's proceed as if she's your witness.
I'd like to lay some foundation for this issue, but
So essentially, she's your witness. You can't ask leading questions. Only the opposite side can ask leading questions. So on cross, you can ask leading questions, but since you called her, she's your witness, you can't. She's a forensic pathologist. The medical examiner was Dr. Thompson, who's really not that skilled at it. Wait, I think she testified in another trial where a dude killed his girlfriend or something, and the state also called Dr. Baden because the family had hired him, and he testified that this ME was wrong. What case is that? What case is that, Ariel?
it was my understanding that this was addressed in our motion and that this had been ruled upon. So I don't want to, this is an important issue for us, and that's why we briefed this issue and cited law and cited the statute, which says that a witness that's identified with an adverse party may be treated as hostile. And again, it's not about, obviously, Dr. Cruz's conduct on the stand, but her identity as the person that she is. I'll ask some questions on this topic, but this is an issue that for Mr. Mullis is important, and that's why we filed the motion that we filed. And we also discussed this at the pre-trial conference, Your Honor, which is why, again, I apologize. When we addressed the issue of how the witnesses were going to proceed, it was my understanding this issue had been resolved.
Certainly. And I understand that there was discussion about calling witnesses out of order. And I think that there was clarity in that regard. I don't recall a specific discussion about this particular issue. And I certainly could be wrong. Counsel, maybe you want to chime in here.
If I may, Your Honor. Certainly, Rule 5.611 sub C for leading questions would not permit them normally on direct examination. And we have hotly contested, I believe, as the court knows, whether or not Dr. Cruz is in fact an agent of the state, because the state for this purposes under Iowa's PCR Act is the Attorney General's office in the criminal justice section. Most of the witnesses, if not all of them, would have been in their concept then a hostile witness and would fall under too broad a scope. Certainly, Dr. Cruz has been openly answering the questions and trying to be responsive to them. And certainly there should be no reason to believe she's hostile yet. Now, should a finding of hostility be found later on, then maybe this could change, but the court has no reason to grant that right now, as she is not associated or called by us at this point in time. And the court's pretrial ruling was not in reference to this as it related to the pretrial motions. So the state would resist that finding.
Your Honor, our motion on this topic is at D0290.
You say 290?
Is that correct? Yeah, D0290.
From 20. That's the motion to admit deposition testimony, yes?
It addresses other topics as well, which includes being able to lead this witness.
And Your Honor, again, I don't believe that the court ruled on that, and that wasn't pertinent to this at this point in time either.
Iowa versus Tyson Grammar. So let me take a look at this case that Ariel just said. So this is Ivan Brammer was sentenced to 65 years in prison after a jury found him guilty of second-degree murder for tampering with a corpse and theft in the death of Eileen Gowan. Gowan, 60, was last seen with Brammer, with whom she was in an on-again, off-again relationship. He was sentenced to maximum 50 years. Okay, Gowan was reported missing in February 15th. Okay, I don't want to know all that. I want to give me the part where I just was reading in the synopsis. Okay, so Brammer was initially charged with tampering with the corpse and theft of the 1500, but prosecutors upgraded the charges after getting a second opinion on the cause and manner of Gowan's death. Dr. Baden, a doctor in New York, consulted on the case and offered his opinion that Gowan's cause of death was traumatic asphyxia due to neck compression and the manner of death was homicide. Where's hers, though? Kelly Cruz, a pathologist in the Iowa Office of the State Medical Examiner, testified to Gowan's autopsy. Multiple blunt force, the level of decomp, Gowan's partially ruined. So Dr. Michael Baden, a renowned pathologist from New York, testified after the prosecution paid him for him to review the case and testify. Baden felt that the autopsy result, toxicology report, and photographs were enough to render a medical opinion. Baden ruled that Gowan's cause of death was traumatic asphyxia. Prosecution rested. So she had determined that the person's manner and cause of death was undetermined based on the level of decomposition. Another pathologist comes in behind her for the same side, which is interesting, saying, no, we can absolutely figure out cause of death, and it was traumatic asphyxia. So she's just not good enough to figure out what it is essentially what they said. She can't figure out what it is. So we'll bring in somebody else to figure out what she can't. That's interesting. Yeah, Cruz does not like it when people raise questions about her findings.
Since it is just about noon, I think probably the prudent thing to do is take our lunch recess. We will excuse the witness for now. We'll pick up any additional argument on this issue that we need to over the noon hour, and then pick back up with the witness's testimony once it's been resolved and everybody knows where things stand. Dr. Cruz, you may step down. Let's plan on resuming at 1:15. Counsel, if you can, well, why don't we take care of this right now? If that works for you?
Yes,
right. Ms. Thompson, any additional argument that you would like to make?
Well, two things, Your Honor. One is, Rule 5.611 is very clear that the issue about leading questions is not just about, I mean, we all understand the classic witness who isn't cooperating in the exam, but that's not what Rule 5.611 speaks to. It speaks to and literally says the court should allow leading questions when a party calls a witness identified with an adverse party. And that is also, as we cited in our motion, what Iowa Code 624.1 says, which allows parties to call agents of public corporations and to treat them as, they are a representative of the adverse party. And we can lay some foundation for this, but it's really undisputed that this witness is an employee of the state of Iowa. There is evidence in the record that she was being advised by Scott Brown as to her conduct in the pre-trial litigation of this post-conviction matter, taking advice and direction from the Attorney General's office about how to respond to the issues in this case. There's no question that she's identified with an adverse party. And so it's not about whether she responds to the questions in an appropriate way. It's simply that she is a person who is associated with an adverse party by the plain text of the rule and by the statute. And that is why we are allowed to cross her, Your Honor.
So just one more thing on this, and then I'll be done, if I may.
Go ahead.
So I'm well aware of the rule that is cited by counsel. But just because she is a state of Iowa employee or that she may have been called as a witness by the state does not substantiate the claim that she is somehow identified with us. The medical examiner goes to great lengths to remain newoneral in their opinions. She is not employed by the Attorney General's office. They are completely separate. I would go back a little bit of a history lesson in that the ME's office used to be part of the Department of Public Safety, and they were moved out of the Department of Public Safety into to Health and Human Services, formerly the Department of Public Health, for that reason, so that they can maintain their neutrality. She gave an opinion that we utilized at trial. They don't like it, and that's fine. But that does not mean that this rule has been, that the terms of this rule would allow them to ask the leading questions in the manner that counsel is claiming she can ask leading questions.
May I make one more point of record, Your Honor?
Go ahead.
I mean, the offer of proof that we'll make, which we can elicit from this witness on the stand, is that shortly before Mr. Mullis filed his post-conviction pleading in this case, my colleague, Ms. Neshawat, wrote a letter to the medical examiner's office directed to this witness, giving this witness information about new material in this case and asking to speak with this witness. And the records that we have reflect that this witness consulted with the Attorney General's office, consulted actually with counsel to my left, and from that conversation determined that it would be inappropriate to speak with Mr. Mullis's counsel, and so she did not. And that reflects that she is taking legal advice or direction in this case from literally the attorney sitting to my left. She did not communicate with us. She is not a neutral party in this litigation, and she remains an employee of the state of Iowa, whose office is in the same building as the Department of Public Safety, who is an employee of the state of Iowa, whose work in this case was in the context as an employee of the state of Iowa. So that's exactly what this rule talks about.
She can't be like, oh, I'm so unbiased, yet I won't even talk to you. I'll only talk to one side.
And the last thing I'll say about this, Your Honor, is were she not a person who could take legal advice and direction from Mr. Brown, and I do not say this to impugn Mr. Brown at all, it's inappropriate for an attorney in litigation under the rules of professional responsibility to advise a neutral witness not to speak with a party. That is one of the core rules of our profession, is that I cannot tell a witness, don't talk to the other side. The only way that it would be even appropriate for an attorney to do that is if that person can give that person legal advice because they are associated. And I certainly don't accuse Mr. Brown of having done anything improper, but the reason it was not improper for him to tell this witness not to speak to us is because they had a legal relationship. And so she's clearly identified with that party. If she wasn't, then there would be another issue that we'd be raising here in terms of professional responsibility, and we're not.
Get him, Thompson.
At this time, the state is not planning on calling her as a witness. Is that correct?
Your Honor, Dr. Cruz is listed as the state's expert witness and would be handled at the same time. To my knowledge, that would go to the court's pretrial ruling as it relates to the breadth of the testimony. I guess on the point of the breadth of this objection is one, citing the rules of professional conduct in this aspect would seek to wrongly impugn an attorney.
Just think about the fact that this whole entire argument is because the attorneys for Todd Mullis want to ask leading questions. If there's nothing wrong with this woman's testimony, and there's no, why they are fighting tooth and nail on every single line to make sure that Todd's attorneys have to fight harder. If you got nothing wrong with your case, buddy, what's your issue? What's your issue here? Stop fighting. This is not that big of a fight. Of all the fights to have, this isn't really a big one to be like needing.
Testimony here, or an attorney's questioning here, there hasn't been, I believe, proof provided in this case, and perhaps I'd love to see it, that would suggest that there was some sort of impropriety. But beyond that, the deposition testimony that they sought to admit into the record already and sought stipulation to, for instance, regarding Dr. Cruz, they were, Mr. Mullis' counsel was completely comfortable asking open-ended questions there, and this sort of accusation would predate that. Again, we have extensively included in motions and resistances what the state means as a party here in this case. And this is just wasting the efforts. They certainly could ask about that in an open-fashioned way. Before this case proceeded, were you contacted by Mr. Mullis' counsel with new evidence? That can all speak to what Dr. Cruz did, but it certainly isn't shaping the lead purpose or why leading questions should be permitted here. And that is just too broad and too improper, Your Honor.
Too broad and too improper. Get over yourself. You know what too broad and too improper? Okay.
Obviously, this isn't as black and white as it normally is. because this is a PCR. And there's already been the underlying criminal trial where some of these people have already testified as witnesses for the state. It's also not as black and white as it normally is because some of these people are employees of the state, albeit in different offices. And some of them have no other place to turn for questions than the AG's office. Looking not just at Dr. Cruz, but at the list of names that are included in the motion that was filed on February 3rd. Obviously, I assume there are some different arguments for some of these other people, but specifically with regard to Dr. Cruz, the responsibilities of the state medical examiner are dictated and directed by statute and rule. They're not controlled by or directed by the Office of the Attorney General. In the absence of some foundation or finding that the state in this matter was directing Dr. Cruz's investigation or autopsy, I don't think she falls under this rule. So not going to allow leading at this point. And I think generally speaking, it's probably going to be the same with regard to the rest of these individuals.
The judge sides with the state of Iowa. On this one, it says, nope, she's not. Susie Q. So the original deadline was March 31st, and then the attorneys asked for an extension. She gave them till April 8th to turn in their briefs for both sides, and then she'll make a decision after that. Okay, then they go to lunch. Let's skip ahead.
And they have measurements on them. Those, it looks like. We'll maybe pick back up with the last thing that we discussed, which was the issue of the demonstrators. Okay. Testimony or switching gears?
We're picking back up, Your Honor. Given what was originally indicated to us as her limited availability, we wanted to accommodate her today by having her called out of order, and we want to move this case forward. So, our views about the court's ruling, we respect it, and we'll proceed. I do have one thing to note, which I'll be brief, but I just think this will help head off objections potentially to just explain one issue for the court before we continue, which is just that the court's ruling was that Dr. Cruz would be limited to the opinions that had been disclosed, meaning, in our view, opinions that she held as of her 2023 deposition. I don't want to open the door to invite, whether she has other opinions that she's developed later, I don't want to invite those. So some of the questions I'm going to ask her are going to be framed in that way, as of your 2023 deposition, so that I'm not opening the door. And I don't want that to be a beginning of a question that prompts objections or some concern about why I'm cabining it. That's the purpose, Your Honor.
So this is interesting.
Understood.
So she was deposed in 2023, and I really still don't even understand. I don't even understand this to date. So I'm hoping that I'll get some explanation as this goes further, because Todd's attorney wants to reference everything. So as of your deposition in 2023, this is what you believed. This is what you believed. This is what you believed. I don't know what's changed from 2023 in her beliefs that she would not want to just leave it open. I don't know if that makes sense, but it's like why she wants to cut off anything from 2023 after. I don't understand that yet. So if you guys come up with why you think that is, let me know. Hi, ATS. Silly Goose says, I worked at DPS DCI. My supervisor previously worked at the ME's office, supervisor of the SOR, worked at the Emmy's office, and several other employees are crossovers. It's like a weird ancestral thing.
And I would consider that simply to be directing the witness maybe to a specific area rather than hopefully leading that would be objectionable. And certainly now that counsel has an understanding that that may be coming, we should all be on the same page.
I don't know why.
If Dr. Cruz is available, great, thank you. Welcome back, Dr. Cruz. Go ahead and have a seat, and I would just remind you that you remain under oath. Ms. Thompson.
Thank you, Your Honor. Dr. Cruz, before we broke for lunch, I think you had told us that you made a determination at the time of the autopsy that the manner of Ms. Mullis's death was homicide, and that's where I want to pick us back up. What are the possible manner of death findings that a forensic pathologist can make?
There are 5 options in terms of manner of death. The most common option is natural. So that's death due purely to natural disease. There's suicide, death at the hands of oneself. There's accident, death due to a hostile environment or unforeseen circumstances. There's homicide, death at the hands of another, and undetermined, which is used when you have all the information available and cannot choose one of the other manners, or you have compelling information for 2 competing manners.
And for a forensic pathologist to make a manner of death finding that a death is a homicide, what is the level of proof that a forensic pathologist needs to have?
There's no exact determination. It uses our medical judgment. I set a very high standard for myself, and often in court, it's termed as to a reasonable degree of medical certainty.
Well, isn't there a standard that to make a finding that a death is a homicide, that a forensic pathologist needs to have clear and convincing evidence that that death was a homicide?
I would put that with a reasonable degree of medical certainty. Clear and convincing evidence is vague. It's really up to the pathologist.
To make that finding, well, let me ask you this. Do you disagree that the appropriate standard is clear and convincing evidence?
I find it to be vague, but that's what other people are comfortable with. I don't have huge issues with it.
Is that the standard in your profession? Clear and convincing evidence?
By whom?
By what the generally accepted practices are in forensic pathology.
I need more information on who's making that general principle.
Is there any general acceptance in the field of forensic pathology about what the level of proof a forensic pathologist needs to have to find that a death was a homicide?
The National Association of Medical Examiners gives guidelines for manners of death. Manner of death can be complicated, and different circumstances require different determinations. So clear and convincing evidence, I would really need more information as to what that means to you or another person in a certain scenario.
And I understand, but my question is Dr. Cruz, not what you understand, but what the generally accepted practices in forensic pathology?
I guess I'm not an expert in terms of who you think everyone is in terms of generally accepted practices.
Jesus Christ.
So that's not a question you're able to answer.
I see what you're getting at, but I've seen that term in the same way I've seen reasonable degree of medical certainty. Sure, I do agree, but I haven't polled every medical examiner to see if that's generally accepted by everybody.
So am I right then that you don't know what the generally accepted standard is in your field for making a determination of homicide?
I would argue that no one knows what everybody thinks within my field.
God.
And you understand that I'm not asking you what everyone thinks. I'm asking you what's generally accepted.
Well, I would have to see where that came from for you to tell me that. I've seen that many, many times, generally accepted practices or in terms of how much evidence you need, how much medical certainty you need. So
Okay.
sure, I'll agree with you.
All right, thanks, Dr. Cruz. Was there any evidence at the time of autopsy that Ms. Mullis died by suicide?
No.
Was there any evidence that her death was a natural death?
No.
Am I right that that left you 3 options for manners of death then?
Yes.
And that left you with it being undetermined, an accident, or homicide?
I suppose.
Well, did you have some other possible finding that was available to you besides those 3 once you'd ruled out natural and suicide?
I think it suggests that I considered accident, which was not the manner of death.
Mike, and I appreciate that, but once you had decided it wasn't a suicide and it wasn't natural, we have 3 other possible options left, understanding you picked one of the 3.
Correct, but I'd like to be sure that that doesn't indicate that was my natural order of thought.
Well,
So fucking argumentative.
understood, and I think that's what we're talking about here today. At the time of autopsy, what was your understanding of the number of times that the corn rake that was at issue in this case had?
It had 4.
And at the time of autopsy, how many penetrating injuries did you determine that Ms. Mullis had in her back?
6.
Did you focus your autopsy analysis ultimately on the cause of those 6 penetrating injuries in her back?
Could you restate that? I'm sorry.
Sure. I mean, was it your determination at autopsy that those that the area where those 6 penetrating injuries were in her back, that those injuries were the cause of her death?
Yes, those injuries were the cause of her death.
So that's the area of her body you were focused on ultimately in making your determination about what the cause and manner of her death were.
Sure.
I want to, and I think you said this to us a second ago, that that at the time of your 2023 deposition in this case, and let me ask you first if you recall being deposed in 2023.
Yes.
At the time of your 2023 deposition in this case, what was your understanding of why Ms. Mullis's death could not have been an accident?
Could you define what I mean, my understanding or how I came to that determination?
Well, let me ask you this. At the time of your deposition in 2023, why did you determine that Ms. Mullis's death could not have been an accident?
My determination of why it wasn't an accident goes back to 2018 and has remained the same throughout. So I can explain that determination if you'd like.
Please do.
So an accident, as it was initially suggested, would say that Ms. Mullis fell on the corn rake. There hasn't been, as far as I know, any argument to the contrary in terms of the corn rake causing her injuries. I conceded at the deposition, and I believe it to be reasonable, that a person could potentially fall on a sharp object, such as the corn rake, once. To think, as a medical doctor, that someone could fall on something backwards, be impaled entirely through their torso, pull that object out through the back of them, then fall on it again, pull it out, and potentially fall on it a third time, which I think seems reasonable, is way outside any degree of medical certainty. There are a number of different injuries that could potentially support a fall, such as blunt force injuries to the posterior surfaces of Ms. Mullis's body, say to the back of her head, her shoulders, her hips, her buttocks, even to her elbows, things that I would see in someone who has fallen, as I have seen many deaths due to falls. None of them were there. So it's lack of supporting evidence for an accident, and also the thought that she could fall on the rake, pull it out, fall on it again, is entirely impossible from a medical standpoint. I also did reason in her additional injuries. She had a number of additional injuries to the anterior surfaces of her body. So to suggest that she fell backward, then somehow sustained injuries to the front surfaces of her bodies, then maybe falling forward, is entirely impossible.
Well, the most compelling finding for you that led you to conclude that this was not an accident was that, and I say this with respect to Ms. Mullis, but I don't really know another way to say it, that there were more holes in her back than there were tines in the rake. Isn't it true that that was the most compelling finding for you that led you to conclude that it was not an accident?
Yes.
And from the testimony you just provided, at the time that you determined that this was a homicide back at the autopsy in 2018, could you envision any way that Ms. Mullis could have fallen on this rake more than once and caused her injuries?
No.
How long did your autopsy of Ms. Mullis take?
I don't recall entirely. I know I had stated in my prior depositions and testimonies about 3 hours.
That is a pretty standard time for you in terms of how long an autopsy would take?
I perform more than one autopsy at a time, so it really depends on the type of cases I have that day. It simply depends.
When you say that you're doing more than one autopsy at once, you have more than one body in the autopsy suite that you're looking at the same time. Is that what you mean by that?
Yes.
Like, that's crazy to me. How in the world are you performing multiple autopsies at the same time? Are you just going back and forth between them? I mean, I could see like you have multiple bodies that are lined up and ready to go for autopsy. Like you do this one, you complete it, you go to this one, you complete it. How are you performing? Could somebody explain that to me? Like, what are you doing? How are you just doing multiple autopsies at the same time?
In your prior testimony in this case, did you say that your autopsy of Ms. Mullis took between 2 and 3 hours?
I'd have to go back and look, but I think that's a reasonable statement.
Well, if I represented to you that that was your prior testimony, do you have any reason to think that's wrong?
No.
And you said that you do more than one autopsy. Let me start that question again. Back in 2018, you said that you would do more than one autopsy at a time.
Yes.
Does that mean that during the 2 to 3 hours that you would have been looking at Ms. Mullis's body, that you weren't spending that entire time looking at her body?
No, I wouldn't be standing there the entire time.
And that's because you'd be looking, is that because you'd be looking at more than one body over that time period?
It would be a mixture of me looking at other bodies, and I have an autopsy technician who assists me with the autopsy process. There are components to the autopsy that they do alone, and I don't need to be there.
In that process where you are looking at more than one body at once, is your attention divided between different cases and different bodies?
Yes.
I don't get that.
Do you know how many different bodies you were looking at during the 2 to 3 hours that you did the autopsy for Ms. Mullis?
I do not recall, no.
Was it more than 4?
No.
Was it more than 3?
It should not have been more than 3 at that period of time. We did no more than 3 in one day.
I do want to talk to you about the information that you had at autopsy. At the time that you conducted the autopsy of Ms. Mullis back in 2018, the time at which, as you testified, you determined that her cause of death was, or that the manner of her death was a homicide. Did you have a short conversation with Dr. Craig Thompson before you conducted that autopsy?
I did.
And Dr. Craig Thompson was a medical doctor, is that correct?
Yes.
Was he a forensic pathologist?
No.
Was he someone who had your same level of qualifications to evaluate injuries?
You'd have to ask Dr. Thompson. I'm actually not quite too sure what type of a doctor he is.
But you understood, at the time you talked to Dr. Thompson, you knew that he was, what did you know that he was not a forensic pathologist?
Yes.
And do you, at the time that you talked to Dr. Thompson, did you consider that you, as a forensic pathologist, had more expertise in determining the cause and manner of death than a person who was not a forensic pathologist?
Yes.
At the time you talked to Dr. Thompson, did he tell you whether he had any concerns about Ms. Mullis's, the circumstances of Ms. Mullis's death?
He told me, as I recall, that he had concerns about her injuries being non-accidental in nature.
And were those concerns that you as a forensic pathologist took with a grain of salt, since he was not a forensic pathologist?
I accepted them. I wasn't dismissive, I think, which is what that suggests. I heard them and said, I will see what I see at autopsy.
When you went, is it true then that when you went into the autopsy for Ms. Mullis, that you had already received information that there was someone who had concerns about her death?
As we established, Dr. Thompson told me he had concerns.
According to her.
So is it true then that you started with the thought in your mind that there was something concerning about Ms. Mullis's death?
I had heard that someone else had concerns, yes, but I had not seen her yet.
Well, it was your testimony that you weren't dismissive of that, is that right?
Correct.
So you were considering that?
Right. I didn't hear it and then forget it. I remembered it and did the autopsy.
Did you hear any information before you went to conduct the autopsy that Ms. Mullis's death was an accident?
Yes.
And where did you hear that from?
That came from Dr. Thompson, who said that, I believe, as I recall, that he was told that she fell on it, but he had concerns about her injuries. We also received intake phone calls, and to the best of my recollection, that was part of our intake phone call, that she may have fallen on the right.
That was was it Dr. Thompson who was reporting that to you?
Most likely.
And what you heard from, is it true that what you heard from Dr. Thompson was that he was concerned that it was reported that she fell, but he was seeing injuries that he found concerning in that context?
He thought her injuries seemed inconsistent with a fall.
After talking with Dr. Thompson, Well, let me ask you this. Did you take any other information about Ms. Mullis's death into your autopsy other than your conversation with Dr. Thompson?
Their law enforcement attended the autopsy. I can't remember exactly what information I was provided, but I'm open to really.
Just for clarification purposes, the person who attended the autopsy is Hemisath.
Any information before I perform my autopsy. I consider myself unbiased regardless of what I hear.
As to what you just said about considering yourself to be unbiased, do you consider at the time you start an autopsy that information that you hear could give you implicit bias?
Could you be more specific?
Well, have you ever heard the term implicit bias before?
I have, and actually only in legal settings. And each time I say, can you be more specific? Can tell me what you mean by it.
Do you have an understanding of what that term means to you?
I think I do, but I actually worry maybe it is incorrect. So you could tell me, that would be great.
Well, I'm not allowed to answer questions from you. I'm sorry. I'm asking you questions. So I'm asking you what your understanding of the term implicit bias is.
I suppose I don't have a strong understanding of it.
Okay. Do you?
That'd be great.
Well, let me come back to that. I want to ask you this. You said that you were open to hearing, and I don't want to misstate your testimony, but was it your testimony that you were open to hearing information about a case before you began an autopsy? I just want to make sure I understood your testimony about that. So I apologize if I've misstated it.
Oh, I'm sorry. What was the question?
Sure. I want to make sure I didn't misstate your prior testimony. Was it your testimony that you were open to hearing additional information related to an autopsy that you conducted?
Yes.
And why were you open to hearing additional information related to an autopsy that you conducted?
Investigative information can be helpful. I do not perform an autopsy in a vacuum. And I think I possess the capabilities to take each bit of information individually and use it if it's appropriate.
When you began Ms. Mullis's autopsy, the information you had about her death came from your short phone call with Dr. Craig Thompson. Is that right?
Most of the information I had was from Dr. Thompson. He's the investigating medical examiner.
And you said most of the information. At the time that you started the autopsy, what information did you have about Ms. Mullis's death that did not come from Dr. Craig Thompson?
Travis Hemisath was there. I don't remember if he provided any extra information. Essentially, the information.
She was found at 3:08 a.m. UTC, which means that Todd killed her. That's what I know. That's Hemisath.
Is Ms. Mullis was purported to have fallen on the corn rake, and then Dr. Thompson said that he was concerned that her injuries did not match a fall on a corn rake.
Did you talk with Deputy Hemisath before you began Ms. Mullis's autopsy?
Yes.
How long did you talk to him for before you began the autopsy?
I do not recall.
Did you have information from any other source before you began the autopsy, other than your conversation with Dr. Thompson and your conversation with Deputy Hemisath?
Not that I can recall at this time.
Now, you mentioned earlier that Deputy Hemisath was in the autopsy of Ms. Mullis with you.
Yes.
Was anyone else in the autopsy with you besides your assistant and Deputy Hemisath and you?
I don't recall. Sometimes I can have law enforcement on multiple cases. I can't say confidently whether or not other people were in the room. There are multiple autopsy technicians as well when I'm doing multiple cases, but no one else relating to the case.
Well, and you said that you have more than one autopsy going on at a time. Is it possible that while you were conducting Ms. Mullis's autopsy, that there were actually other law enforcement officers not even related to this investigation that were also there for the autopsy while you were doing this one?
They would be there for a different autopsy and not involved in Ms. Mullis's autopsy.
Well, they're standing in that situation. Are they standing in the same room with you?
They're standing in the same autopsy suite, potentially. We have different areas for people to stand, different stations for the autopsy. They're separated in that manner. They could also be looking through a window. I simply don't remember, but I do remember that the only person I spoke to from a law enforcement standpoint during the autopsy was Travis Hemisath.
Is it true that you have a clear memory as you sit here today of only speaking to Deputy Hemisath during this deposition and no one else? During this autopsy and no one else?
During the autopsy itself?
Yes.
Other people would be within my office, potentially. We have an investigator on the case, the autopsy technician. I don't recall speaking to anyone else about Ms. Mullis during the autopsy, no.
And the autopsy suite that you're describing, is it an open room with more than one table in it for where the bodies sit for the autopsy?
It's fairly open, yes, and there are multiple tables.
How far apart are the tables?
I don't know.
Are they further apart than 3 feet?
Yes.
Are they further apart than 10 feet?
I'm not entirely sure. You'd have to ask somebody with a tape measure to go and measure them.
Was Deputy Hemosath standing near Ms. Mullis's, where Ms. Mullis's body was during the autopsy?
As far as I recall, yes.
Is it correct that he wasn't looking through glass?
Correct.
To make sure that I understand the order of what occurred, am I correct that you had information from Dr. Thompson? You spoke briefly with Deputy Hemosath before this autopsy. You talked with Deputy Hemosath during this autopsy. And then at the conclusion of this autopsy, you made your findings.
Yes.
There is no requirement that let me ask you the question this way. Is there any requirement that at the conclusion of an autopsy, you as a forensic pathologist have to make your cause and manner of death determination right then?
Not that I'm aware of, no.
It's true that there's absolutely no requirement that that occur. Is that right?
Not that I'm aware of.
And it's your testimony that you are open to more information related to a case. Is that right?
Always.
In this particular case.
I was going to say, not in this case, because we wanted you to look at other information and you were like, oh, hell no.
Did you seek any other information between the end of the autopsy and when you made your finding at the conclusion of the autopsy that the cause and manner of Ms. Mullis's death was homicide?
So in between when the autopsy was complete and when I said it was homicide,
that's
right. I did not. Is there an example of what I could have done? I finished the autopsy and I said it was homicide.
And you asked about examples. That is what I want to ask you about. I mean, given that you are open to, well, I want to get to the issue that you just raised, but I want to go back to one thing for just a moment. Do law enforcement officers come to every autopsy that you perform as a forensic pathologist?
No.
Did you draw any significance from the fact that Deputy Hemosath was at this one?
No.
How long of a drive is it from where Deputy Hemosath worked as a law enforcement officer to where you did this autopsy?
I don't know.
Was it your understanding that Deputy Hemosath was a law enforcement officer in the community that we're in today?
Yes.
How long of a drive is it from here to where you did this autopsy?
I believe it's about 3 hours.
Is it your testimony that you drew no conclusions from the fact that Deputy Hemosath drove 3 hours to be at this autopsy with you?
No, we have many people visit. Some just come for educational purposes. I encourage it. I think it's important for people who deal with death understand what an autopsy is like.
When you talked with Dr. Hemosath or Deputy Hemosath at this autopsy, Dr. Cruz, did he tell you that he was there for educational purposes?
Not that I recall.
I mean, did he tell you he was there to investigate Ms. Mullis's death?
He did.
It was not your understanding at the time of this autopsy he was there to educate himself about your process?
Well, he may have expressed it and I didn't remember. I'm just saying people drive a long ways to see an autopsy pretty regularly.
Had you ever had Deputy Hemosath at an autopsy?
I didn't know how far you drove. I didn't know how far it was. Well, you knew approximately. You're just being fucking difficult.
With you before this one?
Not that I recall.
During this autopsy, did Deputy Hemosath tell you his understanding of how Ms. Mullis had been found in terms of the position that she was found with the corn rake in her that led to her getting medical treatment in this case?
Yes.
What did he tell you during the autopsy about that issue, the position of the rake in her body?
I was told that she was essentially face down and the rake was sticking out of her back. I believe at that time, and I've been told subsequently, that 2 times were said to have been inside her body and 2 times were outside of her body when she was found.
During the autopsy, did Deputy Hemosath tell you that Ms. Mullis had been found?
So Todd remembered that 2 of the times were inside of her body and 2 of the times were outside of her body when she was found. That would have to be a statement from Todd. There's no way that no way. I just can't, maybe, I mean, shit, I guess he was really paying attention to what he was doing, I guess, when maybe he was taking the rake out. I just can't think that he would have remembered that or known that. Well, he removes the corn rake from her back as he's taking her out of the shed because he can't get her out the door with her, with the rake in her. But it's I mean, so the two are completely out of her clothing, and he happens to remember that. I mean, fuck, maybe that's kind of crazy to me. I'd like to see where Todd said that. You know, like I'd go with what she likes to say here is like I'd like somebody to show me where that was actually said. And who actually said that, because that's an odd statement.
With the corn rake in her back, with the handle of the corn rake facing toward her head.
That does sound familiar. I'd have to go back and look. That's how I envision.
Toward her head. The
weapons were said to have been inside her body and 2 times were outside of her body when she was found.
During the autopsy, did Deputy Hemiseth tell you that Ms. Mullis had been found with the corn rake in her back, with the handle of the corn rake facing toward her head?
That does sound familiar. I'd have to go back and look. That's how I envision it when I think back.
And to make sure we're talking about the same thing.
I don't think so.
We understand that she wasn't found in a sitting up position, but I'm not going to get down on the ground for this purpose. But understanding that sitting here today, I'm not in the position that Deputy Hemiseth said she'd been found in. Where would the handle of the corn rake have been relative to my body from your understanding of what Deputy Hemiseth was describing?
The way you had just described it, I would envision the rake handle poking up toward the head.
Am I correct that given what Deputy Hemiseth was describing to you, he was describing the corn rake handle extending from her back up over her head?
Yes.
And we agree that she wasn't in an upright position, but just to make sure we're talking about the same thing.
Yes.
We're talking about the corn rake coming up this way, correct?
Yes.
All right. As you sit here, well, let me ask you this. At the time of your deposition.
That would not make sense because only wounds E and F are the ones that are facing in an upward angle. So it's like, so she's essentially trying to say that he hits her in the back with the corn rake, removes it, creating no blood spatter. Then she falls to the ground and he hits her again, but only hits her with 2 of the 4 times. Can only hit her with 2 of them because there's only 2 that are in the upward direction. So like he would have to be standing, she'd have to go to the ground, he'd have to be standing at her head and then hit it. Yeah, I think it was pointing down too, Crime Ghost. I think this is completely incorrect. I have not watched the biomechanical people on here yet because like I told you guys before, I watched the first 2 days. Yeah, I think I watched the full first 2 days. And then we decided we were going to watch the whole thing, the trial and everything together. So I didn't watch the rest of it because I wanted to watch it with you guys. Well, this is interesting, Connie. How many holes in the clothing? There's a fight between there being 4 or 5. But still not 6. Well, it can't really tell if he has any blood spatter on him because he does pick her up and takes her to the car. So that kind of gets rid of the whole blood spatter situation. But why isn't there any blood spatter in the shed? That's where I'm at with it. That's where I'm at with it then. Yeah, no spoilers.
In 2023, was that your understanding of how she had been found?
Yes.
Was that your understanding at the time of your autopsy?
Yes.
As of the time of your deposition in 2023, had anyone ever told you that that was not how she was found?
Not that I recall.
Did you base your opinions in this case on an understanding that at the time that Ms. Mullis was found, the handle of the corn rake was extending up over her head?
No.
And when you say no, can you explain to me what you mean by that?
How someone said they found the rake, the position of the handle, the position of her body, the rake was removed from her body. If I saw the corn rake like that, then maybe I could take it into consideration, but a simple description such as that had no bearing on my determination and was unnecessary to make the determination of homicide.
why was it unnecessary for your ability to determine whether this was a homicide to try to determine what position the rake was in at the time Ms. Mullis was found?
Ms. Mullis was impaled with the corn rake, and how the corn rake ended up in her doesn't really change the fact that it's homicide.
And I want to make sure that my question, that I want to make sure I asked my.
It actually does. How the corn rake ended up in her absolutely changes whether it's homicide or not. Like, how does that even make sense? She's so stuck in the fact that she cannot be wrong. She won't even think about it a different way. What? How the corn rake ended up in her has no bearing on the fact that this is homicide. He killed her, and that's all I'm going to say.
Question in a clear way. And I'm going to ask that if, with the court's permission, because I don't remember exactly how I worded it, is it possible for the court reporter to read the question back, Your Honor?
It is.
Thank you.
Why was it unnecessary for your ability to determine whether this was a homicide, to determine what? To try to determine what position the rake was in at the time Ms. Mullis was found?
Is the answer, was that your understanding of my question when you gave the answer you just gave?
Yes.
Am I correct that it was not important to you to understand the position that the corn rake was in at the time Ms. Mullis was found?
I would need more information to consider it, such as what injuries were associated with that corn rake in the position in which it were found, if you follow.
Well, at the time of your autopsy, what you were doing was looking at her injuries and trying to understand what those injuries
You're the one who was supposed to figure that out.
Is that correct?
Well, I could tell what her injuries were.
Was the purpose of your autopsy to assess what her injuries were?
Yes.
And so when you say that you would need more information, would it have assisted your analysis of whether or not Ms. Mullis, the manner of Ms. Mullis's death was a homicide, to understand the position that the rake was in relative to her body when she was found with the rake in her?
No.
We've been talking about your conversation with Deputy Hemesath at the time of the autopsy. And during your conversation with Deputy Hemesath during the autopsy, did you discuss with him the possibility of of Ms. Mullis's injuries being the result of a fall?
We did discuss how they were not the result of a fall.
Well, during the autopsy,
we did discuss how they were not the result of a fall, because we were not going to consider that they were the result of a fall. So we could not discuss it because we did not care what position the corn rake was in when it was in her body, because we already determined it was a homicide. So trying to figure any of that out really didn't matter. So we discussed how it was not an accident.
Itself, before you had finished the autopsy, did you tell Deputy Hemesath that it was your opinion that the injuries that you observed during the autopsy were not the result of a fall?
I told him definitively at the end, and he had asked, and we discussed that they were allegedly from a fall, and he asked me, could they be from a fall? And I said no.
Was it your opinion that these injuries weren't from a fall, even before you finished looking at Ms. Mullis's body?
It was determined at the end of the autopsy. Much of the examination is that external examination that begins the entire process. So I had a pretty clear idea before the internal examination began, and did not issue a final opinion until the end. But I was certain at the beginning that it was a homicide.
Oh yeah, she absolutely made the determination before there was any investigation. I think Indiana Girl was talking about that earlier too. At the time of the autopsy, she makes the determination that it's homicide. Hemesath has already made the determination that it's homicide. Dr. Thompson has already made the decision that it's homicide. Nobody was bothering to try to figure out whether it was an accident. That was not even a possibility. And you could tell by the way she just testified that, no, we discussed how it could not be an accident. Now we discussed, is there any possible way it could have been an accident? Because like she said at the beginning, if you have two matters of death or two manners of death that are competing with each other, it becomes undetermined, which is what this one should have been. It should have been undetermined. Yeah, she's a disaster.
And everything else within my autopsy supported that. I remained open throughout and found no evidence to the contrary.
Hey, Lacey, my live is live. What we're watching is from 2 weeks ago. If that makes sense. I know it gets confusing.
Did you determine that Ms. Mullis's injuries were a homicide before you did your internal examination of her body?
Homicide was the manner of choice at that time. However, as I said, I remained open and found no evidence to the contrary.
Wait, what are you talking about? Homicide was the choice at the time, and I found no evidence to the contrary. That statement right there shows that she was not looking at anything other than homicide, because she's saying I found no evidence to the contrary. So you went into it looking at it as a homicide and found no evidence to contradict yourself, instead of going into it open-minded and actually looking at the evidence that was presented in front of you and trying to figure out the position of the corn rake, the position of her body in the barn, and anything that actually had to do with the investigation. Because most medical examiners, forensic pathologists will tell you that they do take things into consideration from the actual investigation of the scene and what was happening. She just said it. I found no evidence to the contrary. Because she went into it looking at it like it was a homicide. I knew I didn't have to express outrage that she did more than one autopsy at a time because he would express it for me. It's just weird. I don't even understand that. I found no SHD today, but I also didn't look. Right, there you go. Yeah, so much power, and look at how she used it. This is what I'm saying. Like, this shit's getting scary. Like, the more of this stuff that we keep watching happening, it's like you get these people that are just adamant that this is what it is, and then it's not about a conspiracy. Nobody's setting Todd up. They just chose that it was a homicide, and they were not going to let it go. Once they locked that in, that was all that they saw. So it's not like there was no planting of evidence, big conspiracy, everybody sit together and try to figure out how we can make this happen and Todd go to jail. It's like, no, they determined it was a homicide, and they were not going to bother to look at any evidence that contradicted that, ever. And now you have a guy that's in prison for the rest of his life and 3 kids that have a dead mom and a dad they can't talk to. You know, and that the original prosecutor in the first trial, like her closing argument still just bothers me so much, when she was like how traumatized like Tristan is based on everything that Todd did. And I'm like, you know what? Like, is there ever going to be a time where like she looks in the mirror and goes, I'm the one who traumatized those kids? Like, I'm the one who traumatized Tristan by locking his innocent dad up for multiple years? You know, Paul says, I only have one question I want asked of Cruz. How do you believe this wound pattern was made in the course of this being a murder? My Kelly Cruz answer would be, the wound pattern would not be relevant in the fact that this was a homicide. Paul. That's my Kelly answer. No, they never bothered to. Never bothered to. Because Dr. Thompson and Hemosath said at the hospital, this is a homicide. They contacted Kelly Cruz and said, we have a homicide. We need you to do the forensic pathology. And then she goes in as a homicide, and she just admitted it on the stand. She probably didn't mean to, but she said, I never found any evidence to the contrary. Well, that's not how you're supposed to start your exam, lady. So saying that she took these things into consideration and then she'd figure it out at autopsy, she just told you that's not what she did. She just told you that she did it. She went in looking for homicide and found no evidence to the contrary. That is a quote directly from her. There was nothing ever going to happen. Nobody was going to bother to look at anything different. So anything that happened after that autopsy and after those that Hemosath, UTC douchebag and Thompson made that decision, that was it. So then they call in Special Agent Turdbutt, and he comes in and he just talks for 3 hours, and Todd just sits there looking at him like, what the fuck are we talking about? Like, what are you even doing? I can't say anything. You're not giving me a second to even speak. And then they use that against him because Turdbutt talks too much. Ugh, so frustrating to me. All right, I've got about a half hour before I have to leave to pick up kids, so I'm hoping that we can get to a good stopping point with her at some point, so then we can pick it up tomorrow. I have kind of a wonky schedule this week to be able to cover this because kids have minimum days and parent-teacher conferences and crazy. I have to do crazy mom shit, so I'm going to do my best to just try to get as much in as I can when I can. It won't be as smooth as like theirs is like day 1, day 2, day 3. I won't be able to do it that way. So I'm still doing it in the parts, and we're just going to keep going by parts.
While you were conducting the autopsy with Deputy Hemosath present, did he ask you if he could bring the corn rake into the autopsy to assist in an analysis of this case?
He asked if he could bring the corn rake closer to Miss Mullis and her clothing items. I said I preferred to keep them separate. The corn rake itself was within the autopsy suite, which is rather large for the purpose of photographing it. The corn rake did not come in contact with Miss Mullis during the autopsy.
I agree, Connie.
During the autopsy, did you photograph the corn rake?
Yes.
During the autopsy, did you compare the corn rake directly with the injuries on Miss Mullis's body?
I examined each separately. As I had said, I did not put them close together, but I examined them separately and within a very small time period.
How far apart were the tines on the corn rake?
I would have to check my notes. I don't quite remember.
Which notes would you like to check to answer that question?
I guess I would have to go back at the photographs because I did not put that in my actual written notes or in my autopsy report.
Was it important to your analysis to know how far apart the tines of the corn rake were?
It was information to consider. Like I said, there had been no information to suggest that anything other than the corn rake caused her injuries. There are some inherent difficulties in comparing a fixed object with the human body, which is malleable and can contort into different positions. So taking straight measurements from an object and comparing them directly with the body is fraught with issues. But measurements such as that are important just to have every bit of evidence possible.
Is there a reason, if it was important for you to have those measurements, that you didn't document them in your notes or your report?
They were documented with photographs, and I can't recall why I didn't simply write it down.
You talked about, during your autopsy, conducting both an internal examination and an external examination of Miss Mullis's body. And I want to ask you, just as to the external examination, you examined during the autopsy, did you examine her face and her head?
Yes.
Did you examine the front of her chest?
Yes.
Did you examine her hands?
Yes.
Did you examine her knees?
Yes.
And I think you told us a minute ago that you did examine, you had the clothing that she'd been wearing accessible to you at the autopsy as well.
Yes.
What was your understanding of what clothing she'd been wearing that would have covered the top half of her body at the time that she experienced these injuries?
I know on the outer layer she was wearing a thick jacket, and I believe she had 2 additional layers of clothing on top.
At the time that you conducted the autopsy, did you look at Ms. Mullis's clothing for any holes?
Yes.
Why did you do that?
The holes were actually quite obvious when we photographed them. It's within our standard procedure to photograph clothing as it is received. So I make note of everything I see.
How many holes did you see on Ms. Mullis's coat at autopsy?
I saw multiple holes. I did not count them.
Why
Were
would
the
why would
holes
you
in her
not count the holes? Why would you not count the holes? You're trying to determine whether somebody was swinging a corn rake at this woman multiple times and you don't count the holes? This is just from a couple weeks ago, Law Junkie. Exact date, I'll tell you. Hold on. February 24th.
clothing important information to help you determine what the cause and manner of her death were?
No.
Not important to help with manner of death.
Did you photograph her clothing during the autopsy with the holes that you'd observed in the clothing marked?
Yes.
Did you take, well, I'm actually going to show you, at this moment, Your Honor, I'm going to show the witness exhibit 524. Is that being displayed?
Yes, she has it now. Yes.
You've been shown, Dr. Cruz, what's been marked as exhibit 524. Do you recognize this exhibit?
Yes.
What is it?
It's an autopsy photograph. This is of Miss Mullis's jacket. It has a ruler with our state medical examiner number on it and a number of arrows that point to defects in the clothing.
Does exhibit 24 accurately reflect the holes that you saw in the jacket at autopsy?
It accurately reflects what I saw at autopsy, yes.
Well, did you or your assistant put 4 large arrows on the 4 holes that you saw in the jacket to document those holes in this photograph?
Yes, my assistant did.
Was this photograph the only documentation of the holes that you saw? Let me ask this question again. Was this photograph, exhibit 524, the only documentation that you made of the holes in Miss Mullis's jacket at autopsy?
There are other photographs. I can't recall if they have arrows or not.
Is it your testimony that there are, well, let me ask you this. Are there any other photographs with arrows marking the holes that you observed at autopsy?
I just said I don't recall.
We were talking about your conversation with Deputy Hemasat for a minute. And I believe it was your testimony that it did not matter to you what position the rake was in at the time Ms. Mullis was found in terms of the ultimate cause and manner of death determinations that you made about Ms. Mullis's death. Is that right?
What someone says in terms of the position, yes. And that's taking someone's description at face value. So no, I did not take it into consideration and did not need to.
Well, did the information about how the rake was found in her body help you to make it clear what caused the injuries?
The fact that a rake was found in her body was helpful, yes.
Did it help you to determine which injuries Ms. Mullis experienced in what order?
No.
Did it help you to determine, well, is it your testimony today that the fact that the rake was in her body in a certain way was not important to your assessment of the cause and manner of her death?
The fact that someone says they found the rake in a certain position was not something I considered or needed to consider.
At the conclusion of your autopsy, did you feel confident that Ms. Mullis's death was a homicide?
Yes.
If you had not been confident at that time that Ms. Mullis's death was a homicide, what would have been the appropriate finding in your case?
I would have pended the case for further review, investigative materials, etc.
And you did not pen the case at the conclusion of the autopsy?
Officially, I did on paper, but verbally, no, I did not. It was determined to be a homicide.
Was the reason that you penned the case on paper because law enforcement asked you to do that so that they could continue an investigation?
I don't have a recollection of if I was asked to,
It's something I would have offered to do. It's pretty standard in our practice. We will withhold cause and manner of death so law enforcement can continue with their investigation so it doesn't jeopardize their investigation.
At the conclusion of this autopsy was whatever was on paper. In your heart, this was not a pending investigation in terms of the cause and manner of her death. Is that right?
Yeah, in my brain, it was not pending.
All right. You did have one, well, let me ask you this. Did you have the toxicology request that was still outstanding at the conclusion of the autopsy?
Yes.
What type of toxicology request did you make at the end of this autopsy?
I ordered what we call a basic panel. It looks at drugs of abuse and alcohol.
Does this basic panel look for prescription medications beyond drugs of abuse?
No.
For Ms. Mullis's autopsy, could you have submitted a request for a toxicology panel that covered prescription medications other than drugs of abuse?
Yes, I could have.
Is that something you did?
No, I did not.
You told me a minute ago that you were open to, that you, in your general practice, are open to other information about your cases other than what you see and observe at autopsy. Is that right?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about where exactly her body had been found?
No.
Did you want any context at the time you determined this was a homicide about where on the Mullis property she had been found?
No.
Did you want any context at the time you determined this was a homicide about what the materials were, what the floor was made of in the area where she was found?
Out of all the information you provided, that would be the most interesting because I do think she did sustain blunt force injuries that could be related to hitting the ground. So I think that information would be useful, yes. But it would not change my manner, sorry.
At the conclusion of your autopsy, how did you know that it wouldn't change your opinion what surface she'd been found on if you didn't know what surface she was found on?
She was impaled in the back with a corn rake, so what she was standing on didn't really make a difference. But it's important to be able to understand all different sorts of wound patterns. And in addition to the injuries on her back that caused her death, she had some blunt force injuries.
Was it, well, as to the blunt force injuries, at the time that you determined that Ms. Mullis's death was a homicide, did you know what had caused any of the injuries that you say were blunt force injuries on her body?
No blunt force. None of them had a pattern that could tell me definitively where they came from.
Is it true then that you did not need to understand what those blunt force injuries were in order to determine that Ms. Mullis's death was a homicide?
I did not need them, no.
I mean, is it true that those blunt force injuries then were not relevant to deciding whether or not Ms. Mullis was the victim of homicide?
They were supportive, but not absolutely necessary for that determination, no.
Dr. Cruz, how could they be supportive if you didn't even know what caused them?
They were supportive, as I had said earlier. She sustained a number of puncture wounds to her back, suggested to be from a fall, which would make the manner of death an accident, which is seemingly the only other option than homicide. If someone falls backwards, they don't get injuries to the front of them. So that supported that she was impaled with the corn rake and did not fall backwards on it.
Is that the only reason in your mind that determining what caused the blunt force injuries wouldn't be relevant to your determination about whether or not this was a homicide?
I think relevant is misleading. It's important to document everything you see and not be dismissive of it. So I take my findings and I do my best to interpret them appropriately. Seeing an injury and then getting additional information as to what could have caused it is always helpful and important for every pathologist to take that into consideration.
Oh, is it? So like the position of the corn rake and like how she was found and where she was found, that would all be important? Oh, wait, no, you just said it wasn't.
Not need them to determine that her cause of death was due to the sharp force injuries of her back. Her death was not due to blunt force injuries.
Was it possible in your mind at the time that you completed Ms. Mullis's autopsy that there could be an explanation for every single one of the blunt force injuries that you observed on her body that would explain that those injuries were caused by her everyday life or an accidental source or something that did not have to do with her being struck by, in your mind, struck by a corn rake?
Are you saying there are explanations like that for them?
I'm asking you, did you consider that possibility at the time you determined this was a homicide?
Blunt force injuries are difficult to interpret, so it's always important to consider that they could have come earlier in the day and may not have been associated with the injuries that caused someone's death. The sheer number of Ms. Mullis's injuries and the nature of them is highly suggestive that at least most of them are associated with her death.
Is that because of, in your mind, the number of other things you observed?
I've performed many autopsies, and the number of her injuries was substantial. And I do not think they were incurred.
FYI, at the time where she did the autopsy of Amy Mullis, she'd only been doing it for approximately 4 months.
During the course of her everyday life.
Well, at the time that you determined that Ms. Mullis's death was a homicide, did you take any steps to learn what the cause of any of the other, what you say were blunt force injuries on her body were?
As I stated, blunt force injuries can be difficult. None of them had a clear pattern to them. So you could take steps to postulate as to how they happened, but there's no way to know for sure. And to say you know exactly for sure how they happened is incorrect.
And Dr. Cruz, isn't it true you were taking steps to postulate how they happened by postulating that in your mind, because of the number of them, they must have been associated with her death?
Get her, Thompson.
I'm not saying exactly how they occurred, which is what you asked me.
But it was your testimony that because of the number of them, it was unlikely that they were injuries that occurred in the course of her everyday life. Wasn't that your testimony?
Yes.
So you were postulating that based on the number of them, even though you didn't know what they were caused by, they were related to her death.
That they were most likely related to her death, at least most of them.
So isn't it true that you were postulating what those injuries were without really having any understanding of why they were there?
I do not know exactly what caused them. However, in my expertise, my medical opinion, those are not due to everyday life. And that's an important determination we need to make as forensic pathologists, because we often get cases, more often than not, when there's concern that someone has a number of injuries, then law enforcement may think that their death may be due to an injury. And we then determine if those injuries could be due to normal everyday life. That's something that's standard to my practice, and I feel very comfortable doing that.
Did you have any way to distinguish at the time of Ms. Mullis's autopsy whether what you say were blunt force injuries on her body were injuries that she experienced in a fall versus from some other source?
Like I said, you can't say exactly what it is. It could be from a fall, absolutely. Striking objects while falling, striking the ground, absolutely.
Okay.
And if the blunt force injuries that you say you observed on her body during the autopsy are consistent with a fall, then how could any of those injuries be supportive of the idea that Ms. Mullis's death was a homicide?
The blunt force injuries were on the opposite side of her body to the other injuries. So either she fell forward or backward, you can pick one.
Is it true that at the time of Ms. Mullis's autopsy, that because you could not envision a circumstance in which Ms. Mullis sustained these injuries, other than someone impaling her with the corn rake, that is the reason you determined that this was a homicide?
There is no other way. Yes.
And that's your opinion based on the autopsy that you conducted and your conversations with Deputy Hemesek?
I'm not sure how my conversations with him helped me come to that conclusion. Without speaking to him, I would have come to that same conclusion at autopsy.
That would have been your conclusion based solely on what you observed at autopsy?
Yes.
And that's because you did not take any steps to learn any context about, for instance, what the surface of the floor was in the area where she was found?
I was able to make that determination without that information at that time, yes.
And you didn't seek that information out?
No, not at that time, no.
Did you need to know at the time that you determined that Ms. Mullis's death was a homicide, whether she had been found with her face resting on a surface for some period of time?
I was aware that her face was on the ground, and I am aware you have someone saying that her face was resting on the floor for such a period of time. She sustained a very large abraded contusion on her jaw. I don't think that's an appropriate explanation of that injury, especially given that she has additional injuries to the left side of her head, such as bruising to her left ear, bruising behind her left ear. But if that's what another forensic pathologist wants to say, then it still doesn't change my opinion.
Well, Dr. Cruz, that wasn't my question, was it? I mean, my question was whether at the time you determined that her death was a homicide, whether you had information at that point about whether her face had been resting on a surface.
I don't recall. I know that I was told that she was prone, so face down, so her face could have been resting. It's a possibility.
At the time you made your determinations, did you take any steps to learn that?
Where her face was?
Yes.
Not that I recall.
At the time that you determined that Ms. Mullis's death was a homicide, did you know where she had been injured?
I'm sorry, could you repeat that?
Sure. At the time that you determined Ms. Mullis's death was a homicide, did you know where it was that she had been injured? Meaning,
location?
Not the location on her body, but the location in the world.
Yeah, I'm very body focused, if you haven't noticed. I was told she was injured on a farm in a shed.
Well, you were deposed in this case, isn't that right?
I was deposed twice.
You were deposed in this case in 2023?
Yes.
And isn't it, do you recall being deposed in this case?
Yes.
Did you testify at your deposition in 2023 that you did not know where it was that she had experienced these injuries?
Correct.
So at the time you determined that her death was a homicide, you did not know where it was that she'd been injured?
No, I was told where she was found. And all that's just information from other people. I have absolutely no idea where she was injured.
At the conclusion of your autopsy in this case, did you certify the death certificate for Ms. Mullis?
I waited. That's that pending cause and manner. I eventually did certify it.
And I understand, I was not intending to imply that you did that immediately, but at some point after you completed the autopsy, did you certify the death certificate for Ms. Mullis?
Yes.
What does it mean to certify someone's death certificate?
A death certificate is a document that has a number of bits of information about a person. The part that I'm responsible for as the medical certifier include the cause of death, the manner of death, how injury occurred, and some other little bits of information. So to certify the death certificate means to place that information into an electronic record, and then I electronically sign it.
By certifying a death certificate, are you certifying that the information on the death certificate is accurate?
Yes.
I'm going to show you what's been marked as Exhibit 354. Your Honor, we're going to show you what's been marked as Exhibit 354, and I'll just make a record that there is some personal identifying information on this record which we've redacted, but otherwise this is a true and accurate copy of Exhibit 354.
Okay, the record will reflect that.
Are you saying Exhibit 354?
Yes.
What is Exhibit 354?
This is Amy Lynn Mullis's death certificate.
Do you see that her birth date and her social security number are redacted?
I do see that, yes.
Other than those redactions, is Exhibit 354 a true and accurate copy of the death certificate that you certified as to Ms. Mullis's death?
That portion that I described that I certify, I can say yes. The decedent information portion is the responsibility of the funeral home, so I'm not necessarily comfortable saying that's true. I don't know where she lived.
Other than the decedent information section, did you complete the remainder?
That those 12 people didn't have enough information to make a decision one way or the other. I know that they did, and I understand, I get what you're saying, but there was no counterpoint, which is this whole purpose is that his attorney did nothing. They did nothing to offer up any type of alternative, which I don't know. I'm still, I mean, I get it. I get people think that he killed her. I get that people think somebody else. I don't. I think there was an accident. The way that her body looks to me, it looks like an accident. I just don't. I can't wrap my mind around it being anybody that killed her. You guys can have your own opinion by all means. I don't think so. I think that it was an absolute weird farm accident. Yeah, and the first trial they both argued that it was murder. Weirdos. That guy's such a douche nozzle.
Of this death certificate?
Most of it, yes. Not that funeral home portion at the bottom, but really that central area.
Understood. Did you complete the portion of this death certificate that provides a medical cause of death?
Yes.
And what did you certify as the medical cause of death for Ms. Mullis?
Sharp force injuries of torso.
Is it your opinion in this case that the injuries that Ms. Mullis had on her torso were sharp force injuries?
Yes.
And does this death certificate provide a space to explain what the injuries that you identify as the cause of death are due to or as a consequence of?
Yes, that's what it said. In this case, there really wouldn't be anything appropriate to put underneath that.
And why is that?
So sharp force injuries of torso are essentially, there are two components of the cause of death on a death certificate. There's the immediate cause of death, whatever condition, injury that ultimately led someone to die right away. That can be due to something else, which is called the underlying cause of death. That immediate cause of death sometimes can be so specific, it really doesn't belong on the death certificate, because ultimately a death certificate is for vital statistics purposes, tracking diseases, injury trends. So that underlying cause of death is really the most important, which is what I put. So the sharp force injuries of torso is that underlying cause of death. If you wanted to put something above it into immediate cause of death, like pneumothorax, something along those lines, you could. But in my opinion, in this case, the sharp force injuries of torso is perfectly sufficient for cause of death.
And did you identify in the certificate the immediate cause of death as you just described?
I did not. And in this case, with an injury that happens quickly like this, one could argue you're getting into mechanism of death territory, which we are instructed not to do by the CDC. So to me, her death was sharp force injuries of torso.
Did you include on this death certificate what the place of her injury was?
Yes.
And what did you say on Ms. Mullis's death certificate the place of her injury was?
Farm building.
Isn't it true that at the time, that by your testimony, at the time you determined the cause and manner of her death, you did not know in your mind where she'd been injured?
Yes.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any context about what Ms. Mullis had been doing earlier that day?
Want is an interesting word. I do like having information about the circumstances surrounding the death, so sure, I would want more information such as that.
At the time you determined that Ms. Mullis's death was a homicide, did you have any information about what Ms. Mullis had been doing earlier in the day that she was injured?
I believe I did. I believe she was working on the farm in some capacity.
Where did you get information about her working on the farm at the time that you determined that Ms. Mullis's death was a homicide?
That would be from law enforcement.
Isn't it true that that's not information you learned until after you had determined that this was a homicide?
I suppose I can't recall clearly. We receive a lot of information in a short period of time, so it's definitely possible I learned it after. But it's a pretty simple bit of information. I don't think it would take too much digging to get that.
Well, in this case, Dr. Cruz, did you receive a lot of information in a short period of time before you determined that Ms. Mullis's death was a homicide?
I guess it's your opinion is that a lot of information. I had information about the circumstances surrounding her death. I didn't have finalized law enforcement reports. And as we established, I can't recall if I had her medical records or not. So I didn't have what one would consider a ton of information, but I didn't need it.
The only information you had at the time you determined this was a homicide was information that you saw at autopsy and that you got from talking with Deputy Hemostat and with Dr. Thompson, correct?
As far as I recall, yes.
And that was not a lot of information.
I suppose that's your opinion.
Well, I'm asking if, in your opinion, was a lot of information.
That's your opinion.
Also being argumentative at this point.
Sustained. At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about the prescription medications that Ms. Mullis was taking?
No, but I had it. Oh, I'm sorry, after the autopsy, I did get that information.
And to be clear, I'm asking about at the time you determined this was a homicide. At that time, you did not know anything about prescription medications that she was taking?
Not
Didn't
that I
matter. It was
recall,
a
no.
homicide.
At the time that you determined that Ms. Mullis's death was a homicide, did you want any information about what emergency responders had observed when they provided her with medical aid?
No.
I do want information about what emergency responders saw, and very much so about what they do, or what they did as part of their resuscitative efforts.
You testified a moment ago about being concerned in your testimony today about injuries that were on the front of Ms. Mullis's body. You know now that Ms. Mullis had resuscitative efforts on her way to the hospital, is that right?
Yes.
Did those resuscitative efforts include her receiving CPR?
Yes.
And did those resuscitative efforts include the use of something called a Lucas device?
Yes.
Can CPR and the use of a Lucas device bruise someone's chest?
Yes.
Is it common for those actions to bruise someone's chest?
Bruise or abrade the chest, yes.
And so any blunt force injuries that you observed on Ms. Mullis's chest that were in the area where CPR is performed, are those injuries that you would expect to be associated with CPR?
It can be difficult if someone has injuries to begin with and CPR is performed in that same area, but I think it's reasonable to say that at least some of the injuries could be from CPR.
Well, in this particular case, would you as a forensic pathologist assume that injuries in that area would be connected with CPR?
I think it's most likely, and I did so. She had a sternal fracture that I determined to be related to CPR.
And you mentioned this a moment ago. At the time that you determined that Ms. Mullis's death was a homicide, did you have any of her medical records from Regional Medical Center?
I do not recall.
Do you remember what day of the week you did Ms. Mullis's autopsy?
Yes.
What day of the week was it?
Monday.
And what day of the week was Ms. Mullis brought into Regional Medical Center?
It was a Saturday.
Isn't it true that you did not get Ms. Mullis's medical records until after you conducted the autopsy in this case?
I think that's the most likely scenario.
At the time you determined that Ms. Mullis's death was a homicide, had you talked with any biomechanical expert?
No.
At the time that you determined Ms. Mullis's death was a homicide, had you talked with any incident reconstruction expert?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have an understanding of the angle of the wound paths on Ms. Mullis's torso?
Yes, I determined, well, the direction of the wound paths within the body. I did not have a specific angle.
At the time you determined that Ms. Mullis's death was a homicide, did you want to figure out the specific angle of the wound paths?
No.
At the time that you determined that Ms. Mullis's death was a homicide, did you have in your mind of exactly how the corn rake entered her body?
She was impaled with it by another person.
And I understand that your opinion is that she was impaled by another person, but at the time you determined this was a homicide, did you have any understanding of how she was impaled?
Didn't matter. She was impaled by another person.
Could she be more specific?
Sure. Did you have an understanding of whether the corn rake was swung into her body?
I did not, no.
Did you have an understanding of whether the corn rake was pushed into her body?
No.
No, didn't matter.
Did you have any understanding of whether the corn rake entered her body in some other way by a person, in your opinion, causing it to enter her body?
It could have been swung, pushed, kicked. Someone else impaled her in the back with the corn rake multiple times.
Wow.
Was it important to you at the time you determined this was a homicide to try to determine which of those routes this was?
That's not something I could do.
At the time you determined this was a homicide, did you want to understand why there had been blood found on Ms. Mullis's hand?
Did I? No.
At the time you determined this was a homicide, did you want to figure out why there was blood on the handle of the corn rake?
See, these are two interesting points. There was blood on Amy's hand, and there was blood on the corn rake handle. Like she had touched her wound, like, oh shit, I just got fucking stabbed with a corn rake, and then grabs the handle.
Want, again, is a hard word. I was aware that there was blood on the rake. I was told that she was found with a rake in her. To me, it supports the implement that caused her injuries. So I already knew all that at autopsy.
At the time that you determined Ms. Mullis's death was a homicide, did you want to understand if there was some connection between the blood on the rake and the blood on her hand?
The blood on her hand has so many potential sources. As you yourself indicated, she received CPR and pretty lengthy CPR. I just don't know the nature of that blood, so to try and connect those two would be inappropriate in my opinion.
Did you take any steps to learn the nature of that blood?
As I said, given all the events that followed Ms. Mullis being found, I don't think anyone could reasonably determine where that blood came from.
And you mentioned earlier that there's an issue in connection with a death where you have a cause and a manner and then also a mechanism. Is that right?
Yes.
What is a mechanism of death?
Mechanism, it's a really specific sort of derangement within the body that causes someone to die. It's discouraged in terms of putting it on the death certificate. Some examples that we see quite often are cardiac arrest. Someone's heart stops beating. Respiratory arrest. Someone stops breathing. Sure, those are ways people die, but really not a cause of death. What made their heart stop? What made them stop breathing? So the mechanism is that final thing of how you actually die, but a cause of death is what led to ultimately to that death.
And I understand your testimony that you did not need to list the mechanism of death on the death certificate, but at the time that you determined that Ms. Mullis's death was a homicide, did you know what the mechanism of her death was?
Yes.
Did you identify the mechanism of her death in your autopsy report?
No.
Did you identify the mechanism of her death in any of the reports that you prepared about your autopsy?
I did not say it explicitly. The description of her wounds from a medical standpoint, it's quite clear, but I did not explicitly state it, no.
What did you testify at Mr. Mullis's criminal trial in 2019 was the cause of Ms. Mullis's death?
Sharp force injuries of torso.
And what did you testify at his criminal trial was the mechanism of Ms. Mullis's death?
As far as I recall, it's the chest cavity being compromised by the coronary tines entering into it, which caused entry of air and some blood leakage into the cavity, albeit not that much. She also had direct injury to her organs.
In that testimony in Mr. Mullis's criminal trial, did you identify which side of her chest had air entering into it as you just described?
Looking back, I believe I had only said the right side, but obviously the coronary tines also entered into the left side of the chest. That would introduce air into both sides of the chest, some blood, and then only on the right side did she have actual injury to organs, and then on the right side of the abdomen as well.
Have you looked back at your criminal trial testimony since the time of the trial?
Yes.
Is your testimony at Mr. Mullis's criminal trial about the mechanism of her death wrong?
It isn't comprehensive, I would say. I was focused on the direct injuries to organs on the right side of the body. I described how air enters into the chest cavities. So I said right, when in reality it should have been both chest cavities.
So it was wrong. She's going to be like, it was incomprehensive. No, it was wrong.
I did explain quite thoroughly how there was injury to the left side of the chest as well. So it was implied but not stated explicitly.
Was it important to you in testifying at Mr. Mullis's criminal trial to be correct about the mechanism of Ms. Mullis's death?
I would like to have been, yes.
Do you agree with me that your description, even by your account today, of what the mechanism of her death was incomplete?
I'd have to look at my wording if I said this is the exact mechanism of death to see if it was truly incomplete or if I was just describing part of the way she died.
And I'd like to show this. The criminal trial testimony for Mr. Mullis's criminal trial, volume 3, is exhibit. One moment, Your Honor.
All right, guys, I'm going to stop it here because I gotta hop off and go get kids and do parent-teacher conference. So we'll pick this up tomorrow morning with her still on the stand. I was trying to get to cross, but we're not going to. There's no way I can get to it today because I'm already running about 4 minutes late. So, but it's very interesting. I told you guys she's. Oh, tomorrow is Reed. Is Reed tomorrow? Oh my gosh! Again, holy shit! Oh, I can't keep up. Well, I'm still gonna do this during the day. It's gonna be a short day. It's gonna be a short day for us because I still have minimum days. But Fishy also said that she might help out. So if I can figure out how to make that work, then maybe Fish can stay here with you guys while I do a kid pickup tomorrow. But we'll see. We'll see. All right, hold on real quick. Okay, so thank you guys for hanging out with me today, watching post-conviction relief on Todd Mullis. We'll pick up with her still on the stand during direct tomorrow morning, same time, same place. As always, thank you guys for hanging out with me, and I will see you mañana. Bye.
Do you dare to follow me down? Head into the unknown, down the rabbit hole, where it stops no one knows.